then our E and Z.
No conflict, Your Honor. John Logan.
Okay,
No conflict, Judge.
all right,
No conflict, Your Honor.
all right. Okay, let's go ahead and have Team E. You want to go ahead and introduce yourselves, and your witnesses can introduce themselves as well.
Yes, Your Honor. Good morning, Your Honor. Members of the jury, opposing counsel. My name is Lily Kim, and I will be conducting the opening statement for the prosecution, the direct examination of Alex Cifuentes, and the cross-examination of Taylor Perkins.
Good morning, Your Honor, members of the jury, opposing counsel. I'm Eleanor Hunt, and I will be conducting the direct examination of Detective Jordan Markowitz and the cross-examination of Avery Becker.
Good morning, Your Honor, opposing counsel, members of the jury. My name is Abby Amon, and I will be performing the direct exam of Kyle Kuzak, the cross-exam of Professor Van Owen, as well as closing arguments.
All right. You want to let your witnesses introduce themselves?
Good morning, Your Honor, opposing counsel, members of the jury. My name is Lauren Krause, and I am Alex Cifuentes. Good morning, Your Honor, members of the jury, opposing counsel. My name is Tate Ham, and I am Detective Markowitz.
Good morning, Your Honor, members of the jury, opposing counsel. My name is Drew Filerman, and I am Kyle Kuzak.
All right, and for Team Z.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Olivia Moraine, and I will be conducting the direct examination of Blake Van Owen and the cross-examination of Jordan Markowitz.
Good morning, Your Honor. My name is Adele Donda, and today I will be conducting the direct examination of Taylor Perkins, the cross-examination of Alex Cifuentes, and the opening statement.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Audrey Davies, and I will be conducting the direct examination of Avery Becker and the cross-examination Kyle Kuzak, as well as the closing argument.
All right, good morning to you all and your witnesses.
Good morning, Your Honor, members of the jury, and opposing counsel. My name is Taylor Davis, and I am Blake Van Owen.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Tommy McKissick, and I am Taylor Perkins.
Good morning, Your Honor. My name is Millie Bjork, but today I am Avery Becker.
All right. All right, let's make sure we get everybody to be sworn in. First of all, team members, if you'd raise your right hand. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? All right, I'm seeing nods. Good enough. Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? All right. And any gallery members, including teacher and attorney, coaches, family members, and friends, do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? All right, and finally, scoring panelists, if you'd raise your right hands, you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with facts, procedures, and rules of the mock trial competition. All right. I don't see anybody trying to interfere, so I'm assuming we don't have any conflicts. So are the people ready to start with the opening statement, or are there any preliminary matters?
Your Honor, we do have a few preliminary matters.
All right, Ms. Hunt, go ahead.
We would like to ask the judge to publish the stipulated facts to the jury.
Well, we can't really do that, but I believe they all have them.
We would also like to ask the judge and for the witnesses to view exhibits on their own screens prior to admission.
All right, we'll do our best to keep up with you. We're all in different places, just so you know. I'm not here with even our scoring panelists, so.
And we also ask that co-counsel may automatically screen share exhibits after they have been admitted into evidence.
Sure. Unless there's an objection to that, I'm assuming the defense has no problem with that.
No, Your Honor, no objection.
All right, very well. That'll be true for both sides then.
And we also ask that any time for direct examination be paused should there be technological issues or cutting out on either end.
Well, hopefully your timekeepers know to do that.
And we ask that any time remaining after opening and closing statements be saved for rebuttal.
I don't know if I've heard the ability to reserve extra time from your opening. That's not traditionally the way the court works. Does the defense have a position concerning that?
We ask that the prosecution only use their remaining time from their closing statements, Your Honor.
Yeah, I think that's the rule we're going to follow. So don't count on anything you say from your opening.
And we ask that these motions be extended to opposing counsel.
I think I did that in the course of things. Does the defense have any additional preliminary matters?
Does Your Honor and members of the jury have copies of our team's trial roster?
No, nobody has your roster. We were probably all, at least I was, I think we were all instructed to kind of scramble along and try to write down as you were doing things. We'll be able to tell from your screen. However, some people have an introduction on their screen as you can look around, so we can't even see your, for example, you, Ms. Moraine, I think it is. I don't know how to spell your last name. I heard you say that, but you can see, we can't see it on the screen. So it probably helps in a lot of circumstances when you're about to say something to say, this is Ms. Moraine for the defense, etc. You know, we're all looking at a bunch of little boxes, and sometimes it's hard to tell who's speaking. You know, when you hear somebody say something, we all assume everybody knows what our voice sounds like, but we've got a lot of voices we're going to be hearing from, so that may help along the way. Okay. Anything further?
No, Your Honor, thank you.
All right, very well. Are the timekeepers ready? Any problem there?
No, Your Honor.
No, Your Honor.
Okay, both timekeepers have checked in. If the people are ready, you can proceed with your opening statement.
Yes, Your Honor. Your Honor, ladies and gentlemen of the jury, Avery Becker was ousted, outraged, and out of control. You will hear today that Avery was on an undeniable quest for revenge, and on March 6th, 2020, she took her actions too far. She broke into her mock trial coach, Mr. Brackman's home, with the intent to vandalize it just as she vandalized his car before. And when she was surprised to find him at home, she used his own self-defense weapon to kill him. As you will hear from several witnesses today, including Avery herself, Avery had a special talent when it came to mock trial. She was an award-winning actor playing the role of a lawyer, an outstanding witness, and had the ability to seem completely believable on the stand. The same place where she will sit and speak to you today. Avery's history of acting out proves that she simply could not handle missing out on mock trial. She has lost her self-control, not once, not twice, but 3 times. The first time, Avery's disrespectful behavior got her ousted from the A team, the place where she was the center of attention. So she encouraged her best friend Taylor to quit the team for her, and Taylor did. The second time, Mr. Brackman gave Avery constructive criticism about her mock trial awards, but Avery became outraged and out of control. She took a permanent marker, she walked out of practice, and she wrote on, she vandalized Mr. Brackman's car. When she got home, she was still outraged. She even told her mother that she was going to get back at Mr. Brackman. Avery has a temper. Does it sound like she makes rational decisions when she's outraged? That brings us to the murder of Mr. Brackman. So the third and last time when Avery was ousted for good, she was overcome with anger and desperate for revenge. She was out of control. Nobody could stop her from her plan. So today, first you will hear from Alex Cifuentes, who will tell you about that plan of Avery's to break into Mr. Brackman's home and show you the text messages that prove it. Then you will hear from Detective Markowitz, who will show you a diagram based off of Avery's cell phone data, the data that proves Avery was near Mr. Brackman's house at the time of the murder. She will show you ring video footage of the intruder, of the same height and build as Avery Becker. Next, you will hear from Mr. Cusack, a crime scene reconstruction investigator for the city of Denver, who concluded that this was a planned burglary gone wrong. Then you will hear from the defense's witnesses. While you listen to Avery, I ask you to listen to her tell you that she was the best on her team, that she won awards, but also that she was angered by Mr. Brackman. Avery will claim today that she had an alibi. Who will give us Avery's alibi? Taylor Perkins, Avery's very best friend Taylor, Avery's most loyal friend Taylor. Not only a conflict of interest, but the alibi doesn't even make sense. You will hear from the defense's expert, Ms. Van Owen, a paid witness who criticizes the prosecution's investigation of the case, but only conducted a partial survey of the evidence herself on which she bases all of her conclusions. At the end of this trial, we, the prosecution, will ask you to declare Avery Becker guilty of murder in the first degree and second degree burglary. Ladies and gentlemen, keep in mind that we do not have to prove to you that Avery planned to murder Mr. Brackman. We have to prove that during a second degree burglary, she killed him. We must prove to you that Avery is guilty beyond a reasonable doubt. And the evidence will show you today that Avery had the motive and intent to trash Mr. Brackman's house. And while she was out of control doing it, she killed him. Avery will tell you today that none of it is true. She will do everything in her power today to try and reverse the consequences of what she did when she was ousted, outraged, and out of control. Thank you.
Thank you. Defense opening statement.
Yes, Your Honor. May I begin?
You may.
Alex Cifuentes had a dream and a plan. Alex spent hours preparing for mock trial, perfecting crosses and directs, and rereading and analyzing the case year after year. But Alex was still no match to Avery Becker. Avery was quick on her feet, intelligent, and a natural mock trial star. The only way Alex could stop Avery Becker would be to lock her behind bars. Members of the jury, this is a case about jealousy, a case about rivalry, and a case about a school dispute between Alex Cifuentes and Avery Becker taken too far. Alex Cifuentes convinced Alex's friend, Blair Rollins, to work together to first murder Mackenzie Brackman in cold blood and then to frame Avery Becker for their malicious crime. Alex wanted to get Avery out of the way so that Alex could be the mock trial star, while Blair Rollins wanted to avenge Blair's father's incarceration. The burden in this case is on the prosecution. The prosecution must prove beyond a reasonable doubt that Avery Becker committed first-degree murder or second-degree burglary. As you listen to the evidence presented today, ask yourself 3 questions. First, how reliable was the murder investigation in this case? Second, where was Avery Becker on the day of Mackenzie Brackman's murder? And third, are there other suspects for this case who might have had a motive and plan to kill Coach Brackman? To answer these questions, the defense will provide 3 witnesses: Blake Van Owen, Taylor Perkins, and Avery Becker. You will first hear from Blake Van Owen, a private investigator who reviewed the police investigation. She will explain that the prosecution's homicide detective, Jordan Markowitz, conducted a rushed investigation and never even considered other possible suspects in this case. Ms. Van Owen will explain the many deficiencies in the detective's investigation, the conclusions about the murder weapon, and the conclusions about cell tower data and Avery Becker's phone. You will next hear from Taylor Perkins, the defendant's best friend. Mr. Perkins will testify that he was with Avery Becker all day on the day of Coach Brackman's murder. He will testify that he and Avery were looking for Avery's lost phone and that they were nowhere near Mackenzie Brackman's house. Mr. Perkins will further testify that the last time he saw Avery's phone was when he and Avery were with Alex Cifuentes at the Fry Shack. And finally, Mr. Perkins will explain how jealous Alex was of Avery's natural mock trial abilities. Finally, you will hear from Avery Becker, the defendant. Ms. Becker will testify that Alex was jealous of her mock trial abilities and that she and Alex were never even friends. She will further testify that she was with Taylor Perkins on the day of the murder, looking for her lost phone. She will tell you that she never could have sent certain text messages from her phone because she didn't have her phone with her. And finally, she will explain her belief that Alex Cifuentes took her phone so that Alex and Blair could set it up to look like Avery had gone to damage Coach Brackman's house. After you hear from these witnesses, the evidence presented will demonstrate that the prosecution has failed to show beyond a reasonable doubt that Avery Becker committed this crime. The evidence presented will conclude that there is no physical evidence connecting Avery Becker to the scene of the crime. In fact, the testimony will demonstrate that Avery Becker was not at the scene of the crime, but rather with Taylor Perkins looking for Avery's lost phone. Finally, the evidence will demonstrate that Alex worked with Blair Rollins to frame Avery so that Alex could fulfill Alex's mock trial dreams. Alex Cifuentes had a dream and a dream to be a mock trial star, and a plan to convince Blair Rollins to murder Mackenzie Brackman and frame Avery Becker. Thank you.
All right, thank you. Are the people ready to call your first witness?
Yes, Your Honor, the prosecution would like to call Alex Cifuentes to the stand.
All right, you've already been sworn in. You proceed.
May I begin?
Yes.
Could you please introduce yourself to the jury?
My name is Alex Cifuentes, Sifuentes.
Tell us a little bit about yourself.
Well, I'm a senior at Colorado High School and I'm on the mock trial team.
Could you please tell us a little bit about your relationship with Avery Becker?
We were good friends and we were on the same mock trial team.
How did you end up on the mock trial team?
Avery actually introduced me to the team.
Let's talk about mock trial. What is mock trial?
Mock trial is a club that simulates a real-life court case with lawyer and witness roles.
How would you describe Avery's role on your mock trial team?
She was very talented as both a lawyer and a witness, and she just had this amazing ability to make things up on the spot and be believable.
How did you know Mackenzie Brackman?
He was our coach for the mock trial team. I just really loved and respected Coach Brackman.
How would you describe him as a person?
He was a great coach and lawyer because he valued hard work and always wanted the best for the team.
Based on your perceptions, how would you describe the relationship between Avery and Mr. Brackman?
From what I could tell, Avery always disliked Coach because he tried to push her to prepare more and be on time, but she never did.
What did Mr. Brackman do about that?
He demoted Avery to the B team.
Could you tell us what that was like?
It was very tense. And then Avery's other best friend, Taylor Perkins, also quit, which then forced Coach to let Avery back on the A team.
How did the team react to that?
Everyone was very upset about Avery being let back on the team, and then even more upset about her awards.
What awards?
She won Best Closing Argument and Best Attorney at the regional tournament.
Why are those awards significant?
Well, Coach tried to tell her that she shouldn't take them as good lawyering because she needed to learn how to properly prepare, but she just got angry and was so out of control.
You say she was out of control. What did she do?
She was outraged. I mean, when leaving—
Objection, speculation.
Response.
Your Honor, this witness has personal knowledge, and this is rationally based off of her perceptions of Avery in practice that day. She was present and witnessed Avery.
Thanks. Further argument?
Your Honor, Ms. Cifuentes cannot accurately testify to Ms. Becker's emotions, as that would be speculation.
Well, the question is, what did she see or what did they do? So please limit your answer to what you have personal knowledge of and what you saw.
May I re-ask the question?
Go ahead.
You say she was out of control. What did she do?
Well, when she was leaving practice that day, she vandalized Coach's Porsche by writing Worst Attorney Award in permanent marker.
Were you at practice when that happened?
Yes, I saw her leave and she looked angry and she grabbed the Sharpie from our paper easel.
Are you sure it was a Sharpie?
We had both Sharpies and dry erase markers in the room, and you can easily tell them apart.
What did Mr. Brackman end up doing about his car?
He didn't even press charges just because he was such a caring coach, but he did kick Avery off the team for good.
Could you tell us what happened after this incident?
Avery texted me and asked me if I would talk to Coach about letting her back on the A team, so I begged him to.
Why did you do this for her?
Well, we were between regionals and state, and even though I honestly would have gotten a bigger part, I wanted the best for the team, and I wasn't going to let my personal interests get in the way of our team's success.
How did Mr. Brackman respond to your question?
Unfortunately, Coach wouldn't let her back on, so I texted Avery and told her what he said.
Your Honor, may I have permission to ask this witness to pull up a copy of Exhibit 14?
To hold it up, did you say?
To pull up a personal copy of it?
Pull it up. Okay, sure.
Could you please pull up a copy of Exhibit 14?
Yes.
Do you recognize this image?
Yes, this is a screenshot of Avery and my text messages after I told her she wasn't going to be allowed back on the team.
When did this text exchange occur?
The night before the incident and right before I saw Avery at the Fry Shack.
What did you do about these messages once you were approached about this trial?
Well, after the horrific incident, I got a call from the detective and I told her about the messages and sent the exact screenshots of the messages to the detective after my interview.
Are these an exact copy of those screenshots?
Yes.
Your Honor, I would now like to offer Exhibit 14 into evidence.
Any objection to Exhibit 14?
Yes, Your Honor, but first I would like to request permission to voir dire the witness.
You may.
Ms. Cifuentes, Exhibit 14 is a screenshot of text on your phone, correct?
Correct.
But if I'm not mistaken, you don't actually have the phone anymore that you claim had the text on them, right?
My phone had been dying for a while, so I did end up having to get a new one.
So that's a no.
I don't have it. No, I have a new phone now.
And those texts don't even have a date or time on them indicating when they were sent, correct?
Not in the screenshot, but they were sent after Avery got kicked off the team.
So, Your Honor, not only do we not know when these texts were sent, but we don't even know if the texts in the screenshot are real. Therefore, I object to the admission of Exhibit 14 into evidence on the grounds of lack of foundation, and I object to hearsay, as Exhibit 14 is an out-of-court statement used to prove the truth of the matter of what is written in the text messages.
Your Honor, may I respond?
You may.
To address opposing counsel's foundation objection, we've established proper foundation that who sent and received these messages, when they were sent, who has access to them, and what the content of them are. And the opposing counsel, I believe, has addressed their evidentiary weight and not their admissibility. It is up to the jury to determine their authenticity, does not influence their admissibility into evidence. And to address her hearsay objection, under Rule 801D2 to Avery's text messages, these are statements made by a party opponent and are therefore admissible into evidence. And to address Alex's statements in the content of the exhibit, under Rule 801C2, they are not being offered to prove the truth of the matter asserted, but rather to show Alex's reaction to Avery's statements in the text messages.
All right, anything further concerning your objection?
As to the objection of lack of foundation, there is no foundation within the exhibit to support the accuracy and validity of the exhibit. And as for the hearsay objection, the text messages are an out-of-court statement intended to prove the truth of the matter asserted of what is inside Exhibit 14.
May I reply?
Briefly.
Your Honor, I'd just like to emphasize that the defense's response addresses the evidentiary weight and not their admissibility. I'd like to stress that it is up to the jury to determine the message's authenticity.
All right, well, concerning the foundational objection, I do have evidence that this phone that these were originally on is not available. However, this is the best evidence available. We do have the person whose phone it is testifying, as well as even if we had the phone, from many other cases I have heard previously, the messages on the phone can be manipulated just as easily as printouts or photocopies of the text messages here. As to the hearsay objection, I do believe the issues raised do go to the weight of the evidence, and the hearsay objections are sustained, or not, they're not sustained, but the reasons for the exceptions are sustained. In other words, I'm overruling the defense objections and allowing in Exhibit 14.
Thank you, Your Honor. Do I have permission for my co-counsel to screen share a clean and unmarked copy of Exhibit 14?
You may.
Could you please read the third to last gray bevel on the second page, please?
Well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house.
Is this what Avery texted you?
Yes.
How did you respond?
I asked Avery what she was going to do to Mr. Brackman's house.
What did Avery say after that?
She said, I'm going to wait till he's at work, and then I'm going to break in and trash it.
Did you tell anyone about what she said?
Not immediately. I mean, I'm her friend. I gave her the benefit of the doubt that she wasn't going to make another mistake after Coach's car. So I just told Avery that it wasn't a good idea.
I'd now like to talk about your last interaction with Avery prior to this trial. How would you describe your most recent interaction?
Well, I saw her at the Fry Shack the evening before the murder, and we had a great talk about mock trial and the team. She even thanked me for talking to Coach, and then she even let me play a game on her phone.
Who else was with you at the Fry Shack?
Taylor Perkins was there as well.
Do you recall someone named Blair Rollins being with you at the Fry Shack that day?
No.
Did Blair participate in mock trial?
No, not that I'm aware of.
Could you tell us who Blair Rollins is?
I went to school with Rollins, but I don't even know if we had a class together. I mean, I barely knew who they were.
Okay, now I just have a few more questions for you. We've talked a lot about Avery's role as a lawyer on your mock trial team. Was she always a lawyer?
She was a witness several times over the years too.
Did you see her as a witness?
Yes.
Did you see her as a lawyer?
Yes.
How did you view Avery's skill level in mock trial, given that you've seen her many times in competition as a witness and a lawyer?
She was really talented. I mean, she was a good lawyer, and as a witness, she came off totally sincere and believable. I mean, she had this amazing ability to make things up on the spot and convince you that they were completely true.
Thank you, Alex. No further questions, Your Honor.
Very well. Any cross-examination?
Yes, Your Honor. Good morning, Ms. Cifuentes. My name is Adele Donda, and I would like to ask you a few questions. You testified that you and Avery were on the mock trial team together at Colorado High School, correct?
Yes, Avery actually introduced me to the team.
And Avery was pretty good at mock trial, wasn't she?
She was good at improvising.
And you were pretty good too, weren't you?
Yes, I worked really hard to get where I am.
But no matter how hard you tried, Avery was always better than you, wasn't she?
She got awarded more, but for the wrong reasons.
And that was frustrating for you that Avery would do so well without trying, wasn't it?
Naturally, it is a bit frustrating to not be recognized for something you work really hard for.
So you'd admit you were a little jealous of Avery.
I mean, the recognition would have been nice, but I cannot be jealous of someone who has Avery's work ethic.
Now, moving on, please direct your attention to previously admitted Exhibit 14. Exhibit 14 is a screenshot you said you took of texts on your phone, correct?
Yes, it is.
But when you met with the detective, you didn't bring your phone, did you?
I knew in order to show them, which I totally intended to do, I had to charge my phone because it was just super finicky. But in the rush of it all, I totally forgot it.
So that's a no?
I did not bring it, no.
So instead you sent screenshots of your phone to the detective, correct?
It was an efficient and reliable way to get the screenshots to them without having to rely on my phone, so yes.
So you're the only one who saw those text messages in Exhibit 14 when they were on your actual phone, correct?
On my physical phone, yes.
And you testified that you don't even have your phone anymore, correct?
As I've talked about, my phone battery only got worse, so I did end up having to get a new one.
So you couldn't even show me the text on your phone right now because you conveniently got rid of the phone, correct?
I wouldn't say conveniently. I mean, my phone had been dying for a long time, and I would have had to get a new one at this same time that I did, regardless of what events were going on.
So we really can't confirm that Exhibit 14 was an actual screenshot then, can we?
The format is in a format of a screenshot.
Okay, so let's assume for a minute that these really are actual screenshots from your phone. Could you look at the top of the screenshot and tell me, is there a time on that screenshot?
Yes, 15:06.
And that's the time you took the screenshot right before you sent it to the detective, correct?
Correct.
But there's no time indication on the individual texts between you and Avery, is there?
Not in this screenshot, no.
So we really don't know when those texts were sent, do we?
Well, they were sent right after Avery got kicked off the team and before I saw her at the Fry Shack.
But is there a date indicating the day the texts were sent?
Again, not in this screenshot.
So these texts could have been sent before or after the murder of Mackenzie Brackman, correct?
Well, I saw Avery at the Fry Shack the night before the murder, so it was before.
But based on the evidence in the exhibit, can we tell if the texts were sent before or after the murder of Mackenzie Brackman?
Not in this screenshot.
And we also don't know if you created the texts or if Avery sent them then, do we?
Well, I know Avery sent them to me.
Now, moving on, let's go back to the day you saw Avery and Taylor at the Fry Shack after Avery got kicked off the team. You and Avery had a good talk that day, didn't you?
Yeah, she thanked me for talking to Coach, and we just talked about the team and mock trial, and it was great.
And Avery even let you play a game on her phone, didn't she?
Our conversation was just so great, and she obviously felt comfortable giving me her phone to play a game on it.
So tell me again, you did have Avery's phone that day at the Fry Shack?
With her permission, and she was totally aware to the fact that I had it.
Thank you. I have no further questions.
Any redirect?
No, Your Honor.
Okay, thank you. People ready to call your next witness?
Yes, Your Honor. The prosecution would like to call Detective Jordan Markowitz to the stand.
Okay, you can proceed.
Hello, Ms. Markowitz. Can you please introduce yourself for us?
Hello, my name is Jordan Markowitz.
What is it you do?
I'm a detective with the Denver Police Department.
Detective, could you please tell us how you are involved in this case?
Well, I was the detective assigned to investigate the death of Mackenzie Brackman, and I was also the responding detective after the police call made on March 6th of 2020.
Before we talk about your findings on this case, I'd like to talk a bit about your background. What type of detective are you?
I'm a crime scene investigator specifically.
What training was necessary to become a detective?
Well, after working for the DPD for 6 years, I was then qualified to become a detective. So in addition to completing police academy and having years of experience in the field, I was eligible to become a detective, and I've been working as a detective for about 7 years now.
Do you have any specific qualifications or training in other areas?
I do actually. I have specialized training and experience with cell phones, and I have a cell phone technology and data recovery certification from the American Academy of Law Enforcement.
What experience do you have in the field of cell phones?
Well, I use the forensic data to download information from a cell phone, acquire and interpret call records, and obtain and interpret cell tower data. And I've used these techniques to download the contents from literally hundreds of phones and have used cell tower data in well over 50 cases.
How do you use these records as a detective?
Well, the information from the cell phone data gives us detectives a lot of information as to where suspects are at any given moment, as well as their regularly incoming or outgoing calls.
Your Honor, at this time, I would like to offer Detective Jordan Markowitz as an expert in crime scene investigation and the gathering and interpreting of data from both cell phones and cell towers.
All right, any objection or voir dire?
Yes, Your Honor. May I please voir dire the witness?
You may.
In your witness statement, you talk about your training and certification in cell phone analysis, correct?
I do, yes.
But you don't have any certification in the area of crime scene reconstruction, do you?
I'm not being admitted as a crime scene reconstructor today, no.
Oh, no. You also don't have any training in crime reconstruction, no degree?
No, again, I'm not being admitted as a crime scene reconstructor today.
So you also don't have any certification or training in the area of crime scene analysis, isn't that right?
None that I specifically mentioned in my witness statement. However, I have been an active cop on duty for 6 years.
For example, in this specific case, you have no specialized training in blood splatter analysis, do you?
Not specifically that I mentioned in my statement.
Your Honor, based on the witness's responses and their admission that they do not have a degree or education in crime scene reconstruction or crime scene analysis, I respectfully request that this witness be limited to giving expert testimony only in the area of cell phone analysis.
Counsel for the prosecution, I'm a bit confused. You have offered your witness as an expert in crime scene investigation, and she seems to indicate he is not being offered as an expert there. So can we straighten that out?
Sorry, you are asking what I'm asking to admit her as?
Well, I wrote down, as you told me, you offered her as a crime scene investigator, expert, and in cell phone analysis. And it seems like the voir dire of your expert was, she indicated, I'm not being offered as an expert in crime scene investigation or reconstruction.
Well, Your Honor, may I
Do
respond?
you have any further questions? It's up to you.
Well, may I respond to that objection?
You can.
Your Honor, this witness can be qualified under experience alone. She has testified that she has been a detective for 7 years. She underwent certification to become a detective after already being a police officer, and that entailed specialized training to become a detective. If anything, this objection goes to the weight to be given to this witness's testimony, not the admissibility of this witness.
And any response to that?
Your Honor, the witness has indicated that she does not have any degree, education, or training in crime scene reconstruction or crime scene analysis. And just because she has experience and training as a detective does not indicate that she is an expert in either of these fields. So I do object to her admittance to give as an expert in the area of crime scene investigation.
All right, well, the Rule 702 indicates that an expert may be qualified by knowledge, skill, experience, training, or education. In addition to experience, it's been my observation that most police officers also receive on-the-job training when they work with partners or other police personnel. So the lack of formal education is not the deciding factor. So the court will recognize the expert as one in accident reconstruction not accident reconstruction, cell phone analysis, as well as crime scene investigation. If there are particular questions that go outside of her expertise, we'll have to deal with those by objection as things come up.
Thank you, Your Honor. Detective, let's talk about the evidence of this case. When did you arrive at the crime scene?
I first got there around 2:20 p.m. after the responding officers and paramedics had all finished their jobs and secured the scene.
What did you see at the scene initially?
Well, before entering the home, I observed the victim through the open front door where I saw Brackman deceased on the floor. And there was a pool of blood on the upper left back and shoulder and underneath the victim, as well as a large knife also covered in blood next to the victim's body. And from that, it was clear that they had been stabbed.
Your Honor, permission for Detective Markowitz to constructively view Exhibit 1?
Sure.
Let me know when you have Exhibit 1 in front of you.
I've got it here, yeah.
What is this exhibit a photo of?
This is a photograph of Mackenzie Brackman deceased just inside the front door of his home.
Is this an accurate representation of the victim as you saw him?
Yes, it is.
Your Honor, at this time, I would like to offer Exhibit 1 into evidence.
Any objection to Exhibit 1?
No objection, Your Honor.
Exhibit 1 is submitted.
Thank you, Your Honor. Your Honor, permission for Detective Markowitz to now constructively view Exhibit 5?
Sure.
Okay, I've got Exhibit 5 right here.
Thank you. Can you tell us what this photograph shows?
This is a photograph of the bloody knife that was next to the victim in the front hallway.
Did you take this photo?
No, I didn't. The forensic team did.
Based on what you saw at the scene, is this an accurate representation of the knife?
It is, yes.
Your Honor, at this time, I would like to offer Exhibit 5 into evidence.
Any objection to 5?
No objection, Your Honor.
Exhibit 5 is admitted.
Thank you, Your Honor. Detective, did you enter the home?
Yes, I did. So upon seeing the victim, I walked around the house and noticed that the side gate and the back door were both open. So I entered the home through the back door, which took me into the kitchen.
What did you observe in the kitchen?
Well, I noticed that everything seemed pretty much intact, though there was a large knife missing from the knife block in the kitchen. And then from the kitchen, I could see over into the dining room where there was both a knocked over chair and a broken plate on the floor.
Your Honor, permission for Detective Markowitz to constructively view Exhibits 8 and 9?
Sure.
All right, I've got the exhibits here.
Great. Can you tell us what these exhibits show?
Exhibit 8 is a photograph of the knife block, and Exhibit 9 is a photograph of the broken plate on the floor in the dining room.
Are these accurate representations of both the knife block and the broken plate as you saw them?
They are, yes.
Your Honor, at this time, I would like to offer Exhibit 8 and Exhibit 9 into evidence.
Any objection to 8 or 9?
No objection to 8 or 9, Your Honor.
All right, those are both admitted into evidence.
Thank you, Your Honor. Detective, did you conduct any other analysis at the crime scene?
Well, I mentioned earlier that I walked around the back of the house, and when I did so, I noticed that there were Ring cameras. So Ring cameras are doorbell cameras that start filming anytime they detect motion. So after downloading the contents of Mr. Brackman's phone, I was actually able to access his Ring account to view the videos that the cameras had taken that day.
Were any of those videos significant?
Yes, actually, I found a couple significant videos.
What did those videos show?
Well, they showed someone about the same size and build of the suspect wearing a mask, hiding their face, and hooded clothing.
What was that person doing?
The camera first picked them up, attempting to open the locked front door, and once they realized the front door is locked, they then went through the back gate a few seconds later. So 20 seconds later, the second Ring camera records them at the back door coming inside the home, and finally the same front door camera captured the suspect running out of the house.
Your Honor, permission for Detective Markowitz to constructively view Exhibit 12?
Sure.
Okay, yeah.
Can you tell us what this video shows?
Yes, so Exhibit 12 is a video of the suspect coming in through the back door and entering the home.
What time was this video taken?
This video was taken around 1:05 to 1:10 p.m.
Is this an accurate representation of the Ring camera footage that you collected through the victim's account?
It is, yes.
Your Honor, at this time, I would like to offer Exhibit 12 into evidence.
Any objection to 12?
No objection, Your Honor.
All right, 12 is admitted.
Thank you, Your Honor. Detective, I would now like to discuss any conclusions you may have come to through your conducted cell phone analysis.
Okay.
Did you obtain cell phone records?
Yes, I did. So Becker's attorney provided me with the phone number for the phone that Becker claims to have lost. And I then got a court order to obtain call detail records from Becker's service provider and cell tower records for March 6th of 2020.
Can you tell us what call detail records are?
So essentially, these are records that are kept to record when you place or receive a call or send and receive a text. These records show the date and the time of the interaction, its status, which is incoming or outgoing, whether it was a call or a text, as well as its duration. Moreover, the record identifies which cell tower a phone communicated with, and it even tells us which antenna specifically on the tower the phone communicates with. And in most cases, almost 100% of the time, it connects to the tower nearest to it.
Your Honor, permission for Detective Markowitz to constructively view Exhibit 15?
You may.
Let me know when you have it in front of you.
Yeah, I've got it here.
What is Exhibit 15?
Exhibit 15 is a copy of the diagram showing the location of both the cell towers that Becker's phone communicated with on March 6th around the time of Brackman's death, as well as the time that those interactions were made.
Did you assemble this diagram?
I did, yes.
And can you tell us what information this diagram summarizes?
This diagram essentially summarizes the call detail records of Becker's phone, and the records are voluminous.
Your Honor, at this time, I would like to offer Exhibit 15 into evidence.
Any objection to 15?
No objection, Your Honor.
All right, 15 is admitted.
Detective, in your experience, what does this diagram tell us about the location of Becker's cell phone?
Well, the CDRs, or call detail records, that I had access to show several calls and texts sent to Avery Becker's phone from another phone prior to the time that Brackman was killed. I later identified this phone as that of Taylor Perkins. And what the data showed was that no call was actually answered, which means that Perkins was calling Becker, but Becker was not answering. So if you'll look at the diagram, you'll notice that Becker received a text at 12:47 p.m. from Perkins through the tower that was covering Becker's house. And then another text was sent 8 minutes later, but again with no response. And finally, there came two incoming, but again, unanswered calls at 1:05 p.m. and 1:06 p.m., followed again by a text message at 1:17 p.m. And all three of these communications went through the antenna that were covering Brackman's residence at the time.
Based off these cell tower records, what opinions can you draw from this summary?
Well, based on my experience and my knowledge of cellular communication, it's incredibly clear to me that Becker traveled from her home on March 6th to Brackman's home and was there from at least 1:05 to 1:17 p.m.
And as a crime scene investigator, detective, did you reach an opinion as to what occurred at the crime scene on March 6th around the time of 1 p.m.?
I did, absolutely. Based on my use of reliable methods applied to the evidence of this case, it is absolutely clear, in my opinion, that Becker was in the house only to be caught off guard by Brackman's presence. And Becker got a hold of the knife that Brackman had grabbed for self-defense and was unfortunately able to stab and kill Brackman.
Thank you, Detective Markowitz. No further questions.
All right, any cross-examination?
Yes, Your Honor. Good morning, Detective Markowitz. My name is Olivia McBain, and I'm going to ask you a few questions. Detective Markowitz, you arrived at the scene of the murder and noticed a body just inside the front door, right?
That's correct. It was Mr. Brackman's body.
And after confirming their ID, you recognized the person, right?
I did, yes.
And you recognized them because you've worked with them before, right?
Yes, I have testified on several homicide cases that Mr. Brackman had been the lawyer for.
So upon realizing the body was Brackman, you thought it possible that he was killed by a, quote, disgruntled ex-client. Is that right?
It was a possibility in my mind, but I always have to follow up.
You never followed up on this theory, did you?
Based on the other evidence that I gathered in this case, it was very clear that it was not, in fact, a disgruntled ex.
You never did follow up on this theory?
Not that I mentioned in my witness statement.
You instead formed your opinion based on what you deemed the first big break in the case, right?
Well, I got a first big break from Alex Cifuentes, and when I applied it to the rest of the evidence that I had gotten in the case.
I'd like to direct your attention to this first big break.
Objection, Your Honor. I ask that the lawyer lets the witness answer the question without interrupting.
Yeah, especially when we're doing this by Zoom, let's make sure we pause a bit to allow the answer to be completed.
You used forensic software to download the contents of Mackenzie Brackman's phone, right?
That's correct, I did, yes.
So this technology that has the capacity to download the contents of a cell phone was available to you throughout the course of this investigation, wasn't it?
It was, and I did use it, yes.
But you didn't use this technology to examine the contents of Alex Fuentes' phone, did you?
Well, at the point when I asked Alex Fuentes to bring in her phone, I assumed she was just really nervous to be meeting with a police officer, and she unfortunately forgot to bring her actual phone with her.
So in your witness statement, you said you received what appeared to be screenshots of text messages from Alex Fuentes, right?
Yes, Alex sent me screenshots that Becker sent to her.
And you received these images from Cifuentes following an interview with them, correct?
Yes, after Cifuentes came to meet with me and we had a discussion, even though she forgot her phone, immediately after she sent me screenshots, yes.
So you never saw these text messages directly, did you?
No, actually, when comparing the evidence with the rest of the evidence that I've found in this case, the screenshots actually aren't needed fully. It's very clear to me that from these text messages, Avery did in fact plan this out, yes.
So you accepted these images from Cifuentes a day after your investigation, right?
I did, yes.
And you didn't ever actually confirm the validity of them, did you?
I fully believe that Alex had no reason to lie about these screenshots, and it's actually incredibly difficult for them to be faked anyway.
So no, you never did confirm the validity.
No, didn't find a reason to.
But you did see these messages as the biggest break in the case, didn't you?
That paired along with Alex's account of how things had transpired with Avery and Mr. Brackman.
So you used unverified evidence to form your theory against Avery Becker?
No, I have very, very ample amounts of verified evidence in this case.
But these text messages, which you have confirmed you did not verify, you did use to form your opinion about the case, right?
I fully believe in the validity of these screenshots and as well as Alex's testimony there. It's very clear to me that this was Avery, yes.
Okay. I would now like to direct your attention to the part of your investigation that focused on the call detail records. You reached out to Avery's attorney to obtain a warrant to search her phone, correct?
I did, yes. But Becker claims to have lost her phone, so I did have to use just her cell phone number to be able to obtain the call detail records.
So while you conducted your analysis, you knew that it was possible that Avery had lost their phone, didn't you?
I know that it's what Avery was claiming and it was what her lawyer was claiming, but I didn't really think it possible.
But you knew that it could have been possible based on what the attorney informed you of, correct?
It's a stretch, but potentially.
Yeah, from this point on in your statement, you referred to the position of the phone as the position of Avery, right?
That's correct, yes.
But it's possible that these are two different things, isn't it?
Well, because the cell phone almost 100% of the time connects to the tower and the antenna that's nearest to it, it's almost 100% that Avery was with her phone. Much more than likely, yes.
But it is possible that these are two different things. Avery and her phone are not necessarily the same entity, are they?
Highly unlikely, but possible.
But you assumed them to be the same entity, didn't you?
Again, because of the knowledge that I have of cellular communication, it's highly, highly unlikely that Avery was anywhere other than with her phone.
Let's move on to the various calls and texts between Becker's phone and Perkins's phone. Your CDRs confirmed that there was cell communication between the phone of Becker and the phone of Perkins, right?
Yes, Perkins was texting and calling Becker, but Becker was not responding for a period of time, yes.
So the duration of the phone calls were extremely short, correct?
Yes, it showed that they had not been answered. That's correct.
But you don't know why Avery didn't pick up her phone, do you?
Well, that matched with the rest of the CDR. It's clear that Avery had been traveling from her home to Brackman's home, and so during the break-in, she was not responding.
But you don't know why Avery didn't pick up her phone. In fact, it's very possible that she didn't pick up her phone because she didn't have her phone, isn't it?
Again, I do believe that is highly unlikely. It is what Becker and her attorney are claiming, but possible, highly unlikely.
So it is possible that Becker didn't have her phone.
Very unlikely, and I don't believe that, but potentially.
Okay. Thank you, Your Honor. No further questions.
All right, any redirect?
No, Your Honor.
Okay, thank you. Further witnesses for the people?
Yes, Your Honor. The prosecution calls Kyle Kuzak to the stand.
All right, you can proceed.
Hi, Mr. Kuzak. Would you introduce yourself?
Yes, my name is Kyle Kuzak, Kuzak.
And what do you do for a living?
I am a crime scene reconstruction investigator, or a CSR for short, and I work for the city of Denver. I was also certified by the Colorado Bureau of Investigation.
What does a CSR do?
CSRs are responsible for investigating crime scenes as well as reviewing photographs and video evidence of crimes. I always assume that all cases will go to trial, and I also organize and document my evidence so that I can easily reconstruct scenes later on.
How long have you been a CSR?
I've been a CSR for 19 years.
What have you done in this time?
Well, in my time, I've had a lot of experience with complex crime scenes, like home invasions and burglaries and stuff like that.
As a seasoned CSR, how are you connected with the events of March 6, 2020?
I actually visited the scene of the crime and I reviewed police reports for the case. And I also looked at photographical evidence as well as video footage and the autopsy report.
And based on your investigation, did you reach a conclusion about what happened?
Yes, I did.
How exactly?
Well, as always, I followed my fundamental principle of letting the evidence guide me to my theory. Or more specifically, I used Tom Bevel and Ross Gardner's 7-step methodology for event analysis.
How do these processes work?
Well, I review contextual information using this step-by-step process, and I note relationships between the evidence in order to help form the chronology of the case. And this is what I've always done, and it's proven to be really reliable.
Your Honor, at this time, I offer Mr. Cusack as an expert in crime scene reconstruction.
Any objection or voir dire?
Yes, Your Honor. May I please have permission to complete a voir dire?
You may.
Thank you, Your Honor. Mr. Cusack, you are not a police officer, isn't that correct?
No, I'm a crime scene reconstruction investigator.
And so you only have a certification in crime reconstruction?
Yes, that is my job.
And you don't have a degree in crime reconstruction?
No, I currently work as a crime scene reconstruction investigator.
So essentially you didn't go to school for this job?
No, I didn't. However, I've had 19 years of experience, so I'm very qualified.
Your Honor, based on the witness's response and their admission that they do not have a degree or education in crime scene reconstruction, they should not be qualified as an expert in crime scene reconstruction in this case.
Response?
Yes, Your Honor. Under Rule 702, experience alone is enough to qualify this witness as an expert, and he has testified to 19 years of experience as a crime scene reconstruction investigator.
Anything further? All right, similar to Detective Markowitz, large swaths of people in sheriff's departments and police departments gain their experience on the job and seeing crime scenes and analyzing data, etc. The court will recognize Cusack as a CSR expert.
Thank you, Your Honor. May I proceed?
Again,
Okay, Mr. Cusack, what is your expert opinion about what happened on March 6, 2020?
This was a burglary that clearly got out of control.
Can you walk us through the steps that led you to this opinion?
Yes, so the first piece of evidence that I reviewed was the Ring doorbell footage.
Why'd you look at the Ring footage?
Well,
Your Honor, may we stop time?
sure. Filerman, Mr. Cusack, can you hear us? Someone able to contact him?
I've contacted him to see if he can hear us.
All right.
One moment. Thank you for your patience. He is currently attempting to rejoin the Zoom.
Thank you.
Judge Stevens, at your discretion, you can decide how long you wait, and if you wish another attorney to step in, it's your choice. Thank you, Judge.
You bet.
Judge, we're trying to see if she's trying to log back in. We're not seeing her as waiting in the room at this point. We'll keep an eye.
It's actually him, Mr. Fileman.
Apologies. Thanks, Judge.
You know, Ms. Ammon, it's up to you how you want to proceed. I know you may want to use some exhibits with your witness in the event they don't call back in or can't establish a connection. You could also have Mr. Fielerman call you, and you can have your phone near your computer, and we would get the audio testimony, or you can substitute. We'll give it another 2 minutes, and then we'll have to make some decisions, okay?
Yes, completely understandable. He's currently attempting to log back into the mock trial website to log in, so I just sent him the password for that. So hopefully he will be in a moment.
Judge, I've just admitted him.
Okay, very good. Kuzak, can we hear you?
Hi,
Okay.
I'm so sorry.
All right.
My Wi-Fi went out.
I believe we were on cross-examination, Ms. T.
Yes. Okay. I believe that we were discussing.
Direct. Oh, okay.
Yes,
Go
Your
ahead.
Honor. No, thank you. And I believe we were discussing the ring footage.
Yes, that's correct.
So why did you look at the ring footage?
Well, ring doorbells are a form of surveillance, and that is very, very essential to crime scene reconstruction.
And what did the footage show?
The footage showed somebody entering the home via the back door.
What occurred once the intruder got inside?
Well, the intruder and Mr. Brackman encountered each other, and Brackman logically would have been notified of their presence via the Ring app because of the subscription that he had. And Brackman then armed himself with a knife from his chef's block.
How do you know he was armed with a knife?
Well, there was an empty slot in the kitchen knife block, and it matched up perfectly with the weapon that was recovered from the body.
Now that the intruder's inside and Mackenzie Brackman is armed with a knife, based on the evidence, what happened?
Well, there was clearly a struggle between both parties that ensued. The two met each other at the back door and then made their way to the kitchen and knocked over a plate.
Now, you mentioned earlier you reviewed Mackenzie Brackman's autopsy report. Would you recognize this report now?
Yes, I would.
Your Honor, permission for the witness to constructively view Exhibit 19.
Very well.
Looking at this report, what is it?
This is the autopsy report in which I reviewed as part of my investigation.
How did you obtain this record?
Well, a coroner is a public official. Therefore, an autopsy report is a public record, and thus it's available to anybody.
And why did you review this?
Well, in order to get the most informed picture possible, I needed to figure out anatomically just how Mr. Brackman died.
Your Honor, I now offer Exhibit 19.
Any objection to 19?
Yes, Your Honor, I object to hearsay as the coroner is not here to testify to the validity of the contents within the autopsy report.
Response?
Yes, Your Honor, to the hearsay objection under Rule 8038, this is a public record, and thus is admissible. Furthermore, it's been sufficiently authenticated under 9017 as he testified that he received it from the coroner.
All right, any further response?
I stand by my objection that the coroner isn't here to respond and to testify to the contents within this.
Well, I think that we can all agree the coroner is not here. However, that doesn't help us get around 8038. It does appear to be a public record. Court will admit Exhibit 19. You can proceed.
Thank you, Your Honor. What does this autopsy report show?
The autopsy report establishes that the knife was lodged into the victim's shoulder blade. So the two therefore must have been in this bear hug position, and the intruder reached over and stabbed Mr. Brackman in the upper back. The report also showed how the knife would have entered the body.
How the knife entered the body? What do you mean by that?
Well, the knife entered facing downward and partially forward. I know that the defense expert Van Owen sees this positioning as unlikely, but I disagree.
Why do you disagree?
It's just not enough basis to dismiss the theory. This is not a seasoned killer, clearly, and they were in the midst of chaos, so it makes perfect sense that the intruder would have just grabbed the knife and may have been seen as an unnatural position.
And who is Professor Van Owen?
Van Owen is the defense expert on this case, and I reviewed Van Owen's theory just to be as informed as possible.
How did this theory alter your opinion?
It didn't.
Why not?
Well, I will admit that some of her opinions are out of my expertise, but I do know that Van Owen is not a CSR, so they can only read reports and use those to base their opinions, which is a lot different from actually being at the scene of the crime.
Can you provide an example of how it's different?
Well, Van Owen believes that the intruder surprised the victim and then stabbed them from behind. But this completely ignores the fact that the Ring doorbell app would have notified the victim of an intruder.
So, through your investigation and review of Professor Van Owen's report, what is your belief on how the events caused the death of Mr. Brackman?
An intruder entered Mackenzie Brackman's home. Brackman was alerted by his Ring app and then armed himself with a kitchen knife. The two then got into a struggle. The intruder grabbed the knife and stabbed Mr. Brackman, leaving him to bleed to death. This was a burglary that got out of control.
Thank you. No further questions, Your Honor.
All right, very well. Any cross-examination?
Yes, Your Honor. Hello, Mr. Kuzak. My name is Audrey Davies, and I'm going to ask you a few questions, if that's all right.
Yes, that's all right.
You testified that you are a crime scene reconstruction investigator who investigated this case, correct?
Yes, that is correct.
But you were not the first investigator on the crime scene, correct?
No, I was not.
In fact, you did not arrive on the crime scene until other investigators had processed the crime scene.
Yes, because that is part of my job. I review all of the evidence that has already been processed.
So you were not the one who processed the scene directly?
No, because that is not my job.
So in order to do your crime reconstruction, you're relying on the crime scene processing that other people completed?
Yes, because again, that is my job. It's to reconstruct the evidence, not to collect it.
So is that a yes?
Yes, because that's not my job.
Thank you. Since you didn't process the crime scene directly, you can't guarantee that this process was 100% accurate, can you?
Well, these people are very good at what they do, and I trust that they were processing it to the best of their abilities, so I trust that.
But you can't guarantee 100% that it is accurate.
I mean, no one can really be 100% about anything, so no, I'm not 100% technically.
Thank you. You mentioned in your witness statement that you would have wanted more evidence. And
yes, I mean, it's always, oh, sorry. You can
no,
continue.
go ahead. You can go ahead.
All right, well, yes, it's always nice to have the most amount of evidence that you can possible. It makes it a lot easier to do your job.
So the evidence that you would have wanted would be DNA, fingerprints. There was none of that at the crime scene, correct?
No, the perpetrator was gloved and completely covered, so it would have been pretty difficult to find any fingerprints or DNA. However, I mean, of course, it's always nice to have DNA. It is very helpful.
So the fact is that you don't have a single piece of concrete physical evidence that connects Avery Becker to this crime scene, do you?
There was nobody's DNA at the crime scene, which includes Miss Becker. So no, there's no biological evidence considering they were gloved and covered.
Thank you. Now let's address the potential evidence that was destroyed, the pictures of the blood droplets. You noted in your witness statement that you saw pictures of blood droplets on the way out of the kitchen towards the hallway, as well as blood splatter on the walls. Isn't that right?
Yes, that is.
And you viewed these photos?
Yes, they were part of my reconstruction.
However, after you viewed these photos, the files were corrupted. Isn't that right?
Yes, however, like you said, it was after I reviewed them, so I didn't have anything to do with the file corruption.
So nobody, including the jury, can see these photos today.
Not that I'm aware of, no. However, I had nothing to do with that.
And without these pictures, nobody can attest to the information that you are claiming is true, can they?
There are no photos here for us to see today. Technically, no.
Thank you. Let's discuss the ring videos. You testified that that you saw these videos while investigating the crime scene, right?
Yes, I did. I reviewed them.
Thank you. In these videos, you can't actually see the perpetrator's skin color, face, or hands, can you?
No, they were gloved and covered, obviously. They didn't want to get caught.
Nor can you determine the person's gender.
No, they were completely covered. However, the size and build was very similar to that of Miss Becker's.
In fact, these videos don't show a single distinguishing characteristic about the perpetrator other than the general height and build, right?
Yes, we got the general height and build, but no facial characteristics, no.
But that general height, there are other people in the world who have this general height and build, don't they?
Of course, however, not with the same motive that Miss Becker would have to break into this home.
So you don't really know that the person in this video is Avery Becker, not with 100% certainty.
It is very, very likely. However, I am not 100% certain, no.
Thank you. No further questions.
Very well. Any redirect?
No, Your Honor, not necessary.
Okay, thank you. Prosecution rests.
Yes, Your Honor.
All right. Ben's ready with your first witness.
Your Honor, the defense calls Professor Blake Van Owen to the stand.
All right, very well. You can proceed.
Good morning, Professor Van Owen. My name is Olivia Moraine, and I'm going to ask you a few questions. To begin, please state your name for the jury.
Of course, my name is Blake Van Owen.
And what is your current employment?
I'm a private investigator.
And do you have any experience in the field of law enforcement?
I do. I joined the Aurora Police Department a while back, and then I worked as a school resource officer. Next, I went into private security, and finally, private investigation.
And have you received any specialized education or training in the field of law enforcement?
I have a master's degree in criminal justice through the Ashford University's online program.
And have you testified as an expert witness before?
I have. I've testified in over 100 law enforcement related cases. 5 of those are related to cell phone evidence, which is very pertinent to this case today.
And what are your specific areas of expertise?
In addition to my job in education, I consider myself an expert in the areas regarding police practices, use of force, false arrest, as well as forensic evidence techniques. In that respect, I've also been qualified as an expert in the states of Colorado, Arizona, Kansas, Nebraska, and New Mexico.
And have you ever had any adverse issues related to your employment as a police officer?
I have. There was a civil suit filed against me a while back while I was working with the Aurora Police Department. There was no wrongdoing on my part, however, and I've grown greatly from that experience.
The defense respectfully requests that the court qualify Blake Van Owen as an expert in the areas of police practice, and forensic evidence techniques.
Any objection or voir dire?
Yes, Your Honor, permission to conduct a short voir dire.
Go ahead.
Ms. Van Owen, you have no training in forensics, isn't that right?
I do not.
And you have no education in the field of forensics?
No, but I've worked on many cases regarding forensic evidence techniques.
So your degree is in criminal justice, not forensics, correct?
Yes, criminal justice, that's correct.
And you're not a forensic scientist?
No.
Your Honor, at this time, I object to Professor Van Owen being availed as an expert in forensic evidence techniques, but not the other area.
Right, a response to that?
Well, given Professor Van Owen's extensive experience and training in the field of law enforcement and her master's degree in criminal justice, she possesses the necessary knowledge, training, and skill to be qualified as an expert in both areas.
Anything further?
I just would like to reiterate that a degree in criminal justice does not carry over to the ability to conduct forensic analysis.
All right, the issue of forensic analysis can be quite broad. Some people are in the area of forensic analysis that don't even have expertise within that field, if that's entirely what we do. So I'm uncertain what the scope of the forensic opinions might be, but it sounds like there's no expertise in the areas such as chemistry, DNA analysis, etc. But we will allow her, because of experience, to testify to forensic practices and her analysis of what happened in this case, as long as it doesn't get into any of those areas, in which case further objection can be advanced by the prosecution. You can proceed.
Thank you, Your Honor. Please tell the jury about your connection to this particular case.
Of course, I was contacted by the defense to conduct a follow-up investigation. They had indicated to me that there appeared to be some evidence the police department had overlooked.
And were you paid to work on this case?
Yes, this is my job, and like any other job, I'm paid as a professional for my time. I'm not, however, paid to give any particular opinion.
And what did you do to prepare for this case?
Well, I've reviewed the police reports, Kuzak's crime scene reconstruction, cell tower reports, as well as the exhibits that Markowitz has prepared. In addition to that, I have also conducted my own follow-up investigation.
I'd like to direct your attention to the part of your investigation that focused on the cell phone analysis. Could you please explain your findings related to the cell phone data in the investigation?
Of course. So when I looked into the cell phone data, I did see that Avery's phone had connected to a tower near Mackenzie Brackman's house.
And what did this finding indicate to you?
Well, cell towers do not show any exact location by any means. Instead, they show a general radius. And so in this case, that means that just because Avery's phone had communicated with that tower near Coach Brackman's house does not at all indicate to me that whoever even had Avery's phone could even see Mackenzie Brackman's house.
And how did your investigation of the cell towers differ from that of Detective Markowitz?
Well, in my opinion, Markowitz was not thorough at all. She was very selective in which records she chose to obtain and those that she didn't. It also appeared that she was only focused on collecting evidence that would incriminate Avery.
So based on your knowledge of the case, which records did Detective Markowitz not obtain?
Well, Detective Markowitz only looked into the records related to Avery's phone, but not any other cell phones that could indicate of other suspects. Additionally, she did not look into any data related to Taylor Perkins' phone, which could have further corroborated Avery's alibi.
So based on your professional knowledge and expertise, what opinion did you form about the cell phone evidence in this case?
In my opinion, the evidence gathered regarding the cell tower evidence is inconclusive and should not be regarded as a vital piece of evidence to this case. It is also important to note that the evidence is consistent with Avery's statement that the phone had been stolen.
I'd now like to direct your attention to your investigation of the intrusion into Coach Brackman's home. In your investigation of the intrusion, what did you review?
I looked at Coach Brackman's autopsy report, the pictures that the police had taken at Coach Brackman's residence, as well as the videos that were downloaded from the Ring doorbell system. In addition to that, I took a photo of my own.
And what did you take a photo of?
I took a photo of a demonstration of how to hold a knife that's very similar to the murder weapon.
I would like to ask Professor Van Owen to please direct her attention to Exhibit 21.
All right.
Are you familiar with this picture?
Yes, this is the photo I took as part of my investigation.
And is this an accurate representation of the picture that you took?
Yes, it is.
Your Honor, may I please have permission to admit what has been marked as Exhibit 21 to evidence?
Any objection or voir dire?
Objection, Your Honor. Under 403, this is unfairly prejudicial.
Response?
Well, Your Honor, this is a picture that Mr. Van Owen has taken to demonstrate a common way to hold a knife. And she's an expert. She's been qualified as an expert to give her expert opinion. And this photo is a piece of evidence which she is using to give that expert opinion.
May I respond, Your Honor?
You may.
Under the 703 balancing test, this photo's minor probative value does not outweigh its prejudicial value, as we do not know that this manner of holding a knife was the one used in order to kill Mr. Brackman.
All right, well, in the opinion of the court, it does show a way of holding a knife. The knife is not bloody. It has, I agree, fairly limited probative value, but the jury has already seen the bloody knife that was admitted, so I don't think this is more prejudicial than that, so I'll allow it for demonstrative purposes the witness may have in using it. You can proceed. It's admitted.
Thank you, Your Honor. I would ask my co-counsel to please share their screen of Exhibit 21. Professor, what does this photo show?
It shows a common way to hold a knife.
And according to your expertise, what is the most common way to hold a knife?
Well, because there are those grooves on the bottom, the most common way to hold the knife is with your fingers in those grooves for a better grip.
And why does the position of the knife matter?
Well, based on my review of the autopsy report, the stab wound found in Coach Brackman's back shows that the knife came from an upward angle. If the knife was being held how I suspect it was being held, once again with your or the perpetrator's fingers in the grooves, the prosecution's explanation of a struggle resulting in the stabbing is inconsistent with the forensic evidence.
How so?
Well, for Coach Brackman to have died during a struggle, as Markowitz concluded, the victim and the perpetrator must have been facing each other, and the perpetrator would have to reach over Coach Brackman's back and stab him in the shoulder, which would require the perpetrator to be significantly larger than Coach Brackman.
And why is that a problem?
Well, this is not only inconsistent with Avery's height, but also the height of the perpetrator on the Ring doorbell videos.
So what then, according to your professional knowledge and expertise, do you think happened?
Well, in my professional opinion and based on my review of all the evidence, I believe it makes far more sense that Coach Brackman was sitting with the intruder standing behind him. It additionally is very unlikely that Mr. Brackman confronted Avery.
And why does it matter if Coach Brackman is sitting with the intruder standing behind him?
Because this negates the prosecution's theory that Coach Brackman surprised Avery and a struggle then ensued.
Thank you, Your Honor. I have no further questions, and I pass the witness for cross-examination.
All right, you can proceed with cross-examination.
Thank you, Your Honor. Good morning, Professor. My name is Abby Amon, and I will be asking you a few questions today. As a former police officer, you know the ins and outs of policing, isn't that right?
I do.
You're pretty versed in this field?
Yes, I would like to think so.
So you eventually quit your job after you were injured a woman, correct?
Yes, I didn't agree with many of the protocols that the police had.
Well, no matter the reason you claim for quitting, the fact of the matter now is instead of working for the police, you work against them, don't you?
I work to find justice with or against them, depending on the given situation.
You make a living deciding and finding where the police have dropped the ball. Isn't that right?
I like to think that I make sure the police doesn't drop the ball. I think it's very important that regardless of what's going on, justice is the overall outcome.
So you don't make a living revealing where the police have dropped the ball?
Well, I look into what the police have done, and then I decide if the police have done a good job, and oftentimes they have. But in this given case, I believe that, yes, the police did drop the ball.
Ms. Van Owen, I'm still a little confused. Is that a yes or no, you make a living revealing where the police dropped the ball?
That is one way to put it, I guess, yes.
Okay, thank you. So as versed in the field of policing as you are, would you agree that under policing, there's crime scene reconstruction, cell tower analysis, and general police investigation?
Yes, I agree with that.
Okay, so with that in mind, let's take a look at your review of the police investigation, beginning with Detective Markwitz's cell tower opinions. You would agree that this falls directly in cell tower data, which is one of your specialties, correct?
Yes.
And you claim that Detective Markowitz only subpoenaed the information from a limited time frame and of Avery's phone, right?
That's correct, he did, yep.
In your words, she was selective, right?
Yes.
Yet you didn't attempt to gather any information from a larger window or of anyone else's phone, isn't that right?
That's correct. I used the evidence that was already collected to form my opinion.
So you did no further investigation on your own, right?
That is not true. I investigated and looked into all the evidence that was presented to me, and then concluded that my theory was different than that of the police department.
I'm sorry, maybe I should have been a little more clear. Referring specifically to the cell tower data, you did not do any further investigation, right?
Yeah, that is correct.
And that's because you were also selective. You saw the information that you didn't like and just wanted to make the police look bad, correct?
That is not true. I looked at all the evidence and I went through many different scenarios that could have taken place, and I concluded that Avery was not guilty.
You found a flaw, made no attempt to really solidify your theory, right? You just went with what you had?
I did go with what the police had collected. Yes, that's true.
Okay, so next, you discussed how the knife potentially could have been held. You demonstrated or showed a demonstration of the way that a knife was constructed, yet you have no evidence that this was the manner used to kill Mr. Brackman, correct?
I think based on the autopsy report and also the given circumstances of the height of the perpetrator, it is the most common way that the stabbing took place.
Well, common or not, I think we've already established this is a relatively uncommon situation, and you can't tell us for a fact that this was the way the knife was held during the murder of Mr. Brackman, can you?
Unfortunately, there are not any solidified facts, but I think that's where it's really important that you do a great job investigating. I like to think that I look at all the evidence and come up with the most probable chain of events that could have taken place, and that's what I did here today.
You just said that you should look at a thorough investigation, lots of evidence, right?
Yes, that's correct.
You yourself conducted a partial review of the evidence, correct?
That is correct. That's my job, to partially reevaluate what the defense believes the police did not do a good job looking into.
Okay, so that is a yes, partial investigation, or not even investigation, review of the evidence.
It was an investigation, but yes, it was partial.
Thank you. No further questions.
Very well. Redirect.
Yes, Your Honor. Professor Van Owen, does the fact that you were paid to work on this case skew your ability to form an evidence-based opinion about this case?
Absolutely not. I like to think that I do a great job, a non-biased job, looking at everything, all the evidence that has been collected, and then conducting my opinion.
Thank you, Your Honor. No further questions.
Any recross?
No, Your Honor, none necessary.
Okay, thank you. Next witness.
Yes, Your Honor. The defense would like to call Mr. Taylor Perkins to the stand.
All right, you proceed.
Please introduce yourself to the jury.
Hello, my name is Taylor Perkins.
Mr. Perkins, do you know someone named Avery Becker?
Well, yeah, of course I know Avery. She's my best friend.
Do you also know someone named Alex Fuentes?
Yeah, I know Alex.
Please tell the jury who Alex is.
She was one of our teammates on the mock trial team.
How would you describe Alex's personality?
Alex just has this way of being like totally insincere in a passive aggressive kind of way.
Objection. Under Rule 403, this evidence has very small relevance, but is extremely prejudicial against Alex Fuentes. In addition to the witness not providing any evidence or examples of this behavior, its prejudice outweighs its relevance.
Your Honor, Mr. Perkins is allowed to testify to his personal knowledge and observations of Alex Cifuentes as he personally knows Miss Cifuentes.
May I respond?
Sure.
I believe that my opposing counsel's response does not address my objection under Rule 403.
Anything else?
Your Honor, this is relevant as it goes to the dynamic between Avery and Alex and a possible motive to frame Avery in this case.
Well, relevance is always kind of an overarching requirement, but then we look to see concerning the prejudicial effect under 403, and you were talking on the defense side about the witness's personal observations, but we didn't get to any personal observations, so this is just an amorphous kind of an opinion that's incapable of being cross-examined. So if you have specific instances, you may want to look at that. The objection is sustained.
Mr. Perkins, from what you know, do Alex and Avery know each other?
Yeah, well, we were all on the mock trial team together, so yeah, we all knew each other.
And from what you've observed, can you describe the relationship between Avery and Alex?
Well, I knew Avery pretty well, and I knew Avery well enough to know that she and Alex really didn't get along at all. I mean, they were always fine on the surface, but deep down, they were never really cool with each other.
Now, moving on to your mock trial team. Were you on the mock trial team at Colorado High School?
Yeah, I was.
How long have you been on the team?
I was on the team for a pretty long time.
Did there come a time when you were no longer on the mock trial team?
Yeah, I ended up quitting after Avery got demoted.
Do you know who Mackenzie Brackman was?
Yeah, he was a mock trial coach.
And from your observations, how would you describe the relationship between Mackenzie Brackman and Avery Becker?
Well, I mean, every relationship has its ups and downs, but I wouldn't call it anything too crazy, you know?
Can you explain the incident with Avery and Coach Brackman's car?
Well, Avery accidentally used a Sharpie to vandalize Coach Brackman's car, but I know for a fact she thought it was a dry erase marker. And I mean, come on, like, who hasn't made mistakes? I don't think one incident should ruin a person's character.
Now, moving on, did you ever run into the mock trial team outside of school?
Well, yeah, I mean, we went to the same school together, so obviously we saw them there, but there was one time at the Fry Shack on March 5th that was especially bad.
What happened on the evening of March 5th at the Fry Shack?
Well, Avery and I had gone to go get something to eat, but it ended up being a pretty bad idea because the whole mock trial team went there after practice, and it got kind of awkward.
Can you explain the interaction between Avery and Alex that day?
Well, Alex came and sat down at our table and was, doing her passive-aggressive kind of thing. And it really got to Avery to the point where Avery stormed off to the bathroom and even left her phone behind, which is like so not like her. I mean, that thing's like her third arm.
What happened after Avery went to the bathroom?
Well, I had to put up with conversation with Alex for a little bit. And then when Avery came out, we just left.
When was the last time you saw Avery's phone?
Well, I saw it sitting on the table at the Fry Shack before Avery stormed off to the bathroom, and after that, I don't know what happened to it.
Did you and Avery look for her phone?
Well, yeah, that next day, Mark said,
I'm sorry, Mr. Perkins. I think your Zoom
yeah,
froze
it
for.
just said my connection's unstable,
Um,
but I can hear now.
I'll repeat the question. So, can you explain a little more? Where were you and Avery on March 6th?
Well, like I was saying earlier, we're looking for a phone, so we kind of just retraced our steps from the day before. We went to the Fry Shack, we went to the mall and looked at all the stores that we had been to the day before, but we just couldn't find it anywhere.
Was Avery near Mackenzie Brackman's house on the day he was killed?
No, Avery was nowhere near Mackenzie Brackman's house that day.
Are you sure?
Positive,
How are you sure?
because she was with me.
Now, moving on, do you know someone named Blair Rollins?
Yeah, she went to our school.
How do you know Blair Rollins?
Well, everyone knows Blair's a little off. Like I don't know, she just kind of has a weird thing to her. And what's actually weird is she hated Brackman too.
And objection, hearsay under Rule 801.
Silence.
Your Honor, it is not hearsay as it is not being offered for the truth of the matter asserted, but rather for its effect on the person who heard it.
Anything further?
I stand by my objection.
Well, it's not really a statement, is it? It's more of an opinion. So objection's a little misplaced. You have to have a statement before it can be hearsay, and there wasn't offered as a statement, so overruled.
So moving on, from what you know, did Alex and Blair know each other?
Yeah, I think they were actually pretty good friends.
Objection. Under Rule 602, this witness has no personal knowledge of that relationship, and the defense has not established proper foundation that he does know about this relationship.
Your Honor, I have laid adequate foundation to establish Mr. Perkins' personal knowledge of Alex and Blair separately, meaning he is certainly qualified to testify to their relationship as he personally knows them.
May I respond?
Yeah.
The opposing counsel has not asked this witness if he has ever seen them hanging out or anyone has ever told them that they were friends, or if he's ever seen them as friends in any context, in any situation.
All right, I think from a technical standpoint, I was in high school. I know how relationships go, but I think the prosecution's objection is well placed. Knowing two different people doesn't necessarily mean you know the relationship between those two. So if there's further foundation, you may want to address that. Sustained objection.
Yes, Your Honor. Did Alex and Blair have any sort of relationship that you observed?
Well, yeah, from what I knew, they were pretty good friends.
So, based on what you knew, did Alex and Blair have anything in common?
Well, to my knowledge, they both had reasons to hate Coach Brackman.
So, based on what you know, why do you think Alex hated Mackenzie Brackman?
Well,
objection, speculation.
Response?
Your Honor, this is not speculation, as the witness is simply stating his observations based on his personal knowledge, as I have laid adequate foundation to establish that Mr. Perkins did in fact know both Alex Cifuentes and Mackenzie Brackman.
Anything further?
The fact that opposing counsel has established that foundation does not mean that this witness can testify to how Alex may have been feeling towards Mackenzie Brackman or Avery Becker.
I agree. I'll sustain the objection. Based on what I've heard, it's a speculative opinion.
Yes, Your Honor. May I continue?
Sure.
So, Mr. Perkins, from what you know and from what you've seen, how many other people from your school did not like Coach Brackman?
Well, to my knowledge, both Alex and Blair had reasons to not like Coach Brackman.
Your Honor, I have no further questions, and I pass the witness for cross-examination.
All right, cross-examination.
Yes, Your Honor. Hello, I'm Lily Kim. It's nice to meet you. You are best friends with Avery Becker, right?
Yeah, I love Avery. I mean, like, I don't know. Avery's just one of those people that you could like talk about forever. You know, she's super sweet, great person. I think I'm really lucky to know Avery Becker.
Right. And on the day that Mr. Brackman was killed, you ditched school for Avery, right?
Well, I mean, like, you know, I was kind of benefiting too. School could be a drag sometimes. But yeah, I mean, I wanted to help my friend find her phone. You know, that's kind of what friends do.
Right. So you skipped the entire day of school because Avery needed to find her phone, correct?
Well, yeah, I mean, like I said, I got to get out of school, not to mention I just wanted to help my friend out, and it wasn't that bad of a day, I guess. So, yeah.
In your direct examination, you said that Avery's phone was like her third arm, her third kidney, never out of reach, right?
Well, yeah, that's what made it so strange when she left it behind and stormed off to the bathroom. I guess Alex must have really got to her. Because, yeah, normally she wouldn't leave it anywhere behind. So that's why that stood out to me.
But you and Avery didn't notice that her phone was missing until the day after she lost it, correct?
Well, yeah, I mean, I just that next day, normally Avery would pick me up from school, and she would normally text me before that. So I had texted Avery to see if she was coming to pick me up for school, and when she picked me up that morning, we realized she didn't have her phone when I asked her why she wasn't texting me.
So that's a yes.
Yeah.
So if Avery was so attached to her phone, like you say, wouldn't you say it's a little bit unusual that it took you guys that long to notice it was missing?
Well, I mean, like I said, that's what made it stand out to me so much when she left it behind. So I guess Alex must have really had her rattled. I mean, Avery did care about mock trial a lot, and I think having to see the whole team there must have made her pretty bummed out.
But you don't know Alex had her phone. That was just your guess.
Well, no, I mean, like I said, I can only speak to the last time I saw it, and the last time I saw it was sitting on the table at the Fry Shack with me and Alex there, and then that next morning, I know Avery didn't have it, so.
Yeah, right. So you claim that Avery didn't kill Mr. Brackman because she was with you looking for her phone all day, right?
Well, I don't claim. I know for a fact my friend was with me that day, and we were retracing our steps.
Right, looking for a phone that happened to be lost, even though it never leaves Avery's side, right?
Well, yeah, and I mean, like I was saying earlier, that's what made it so so shocking when she left it behind. So, yeah.
Okay, thank you, Mr. Perkins. You wouldn't have done mock trial if Avery hadn't done it, correct?
Well, yeah, I mean, I probably would have rather spent the time doing other things, but it wasn't that bad. I got to hang out with my best friend, and, I kind of felt like we were a dynamic duo a little bit. So, yeah. But I'd say Avery was probably the main reason I did mock trial.
And from what you've observed of Avery's participation in mock trial, you notice that Avery doesn't really put in any effort, correct?
Well, I mean, I guess I'd say she definitely slacks, but at the same time, she didn't even need to put in all that much. I mean, she was by.
But Your Honor, may I pause the time? I believe the witness is getting out.
Sure. Looks like our witness is dialed back in. Here we go.
Oh, all right, I'm back.
May I re-ask my question?
You may.
Yeah.
And from what you've observed of Avery's participation in mock trial, you know that Avery doesn't put in effort, correct?
Well, yeah, I mean, like I was saying, I don't think she definitely didn't put in as much as everyone else, but I don't think it really changed the outcome at all. I mean, she was still by far the best lawyer, you know. I mean, like I said, she has the awards to prove it. So even though she might not have put in as much effort as everyone else, I don't think it really was that much of an issue.
So that's a yes.
Yeah.
And your coach, Mr. Brackman, was very frustrated by this behavior of Avery's, wasn't he?
Well, yeah, I mean, I think Brackman was kind of a subpar lawyer. So I bet seeing one of his students being able to do his job so much better than him probably got to him a little bit.
Mr. Perkins, I didn't ask about Mr. Brackman what he thought of Avery. I asked you if he was frustrated by Avery's behavior, correct?
Well, yeah, I mean, like I was saying, I think
overruled. Go ahead.
What? Oh, okay. Well, yeah, like I was saying, I think it did get to Brackman a little bit that Avery was able to do so well while not putting in as much effort as everyone else, you know?
Right, so he kicked Avery off the team because of it.
Yeah, well, that just felt unfair to me. I mean, like, sure, you can not like Avery because she didn't put in as much effort, but she was clearly the best on the team. And I think Brackman was just letting his personal feelings get in the way of what was best for the team.
I believe you're getting a little bit away from my questions, and I'd appreciate it very much because I have limited time with you today. If you'd answer my questions a little bit more directly. He did kick Avery off the team, correct?
Well, yeah, he did kick Avery off the team.
And right after he kicked Avery off the team, you quit in support of Avery. Isn't that right?
Well, yeah, I mean, like I said earlier, I was mostly on the mock trial team for Avery anyway, and she cared about mock trial way more than I did. So it really wasn't that much of an issue for me to step down for her. I mean, like, I was happy to have the extra free time anyway.
But Mr. Mackman did let Avery back on the team eventually. He did, right?
Well, yeah, he had to, after I stepped down, he had no choice other than to put Avery back on. So yeah, he did end up letting her back on.
Even though Avery tended to act in a rash manner?
Well, yeah, I mean, like, I don't know. I think that her good lawyering skills probably overrules that she was a little impulsive sometimes.
Right. So Avery has a temper, wouldn't you say so?
Well, I mean, like, I think Avery's human, you know, when someone's really getting on your back, it'll get to you sometimes, you know, but I don't think she's anything crazy.
But one time she was so angry that she vandalized Mr. Brackman's car, correct?
Yeah, but I think that's kind of ignoring some of the context of that situation. From what I heard, Brackman was really being mean to her. I mean, saying she didn't deserve her awards and that she was like a fraud or something like that. I mean, I don't know. I think that question almost like ignores some of the context around that situation. But yes, I mean, she did vandalize his car, but I think there's also something to be said that she thought she was using a dry erase marker, not a Sharpie.
Well, I'm not talking about what marker she thought she used, but she was so upset that she willingly marched out of practice.
Speculation.
Oh, I need to hear the whole question first.
Avery was so upset that she marched out of practice with a permanent marker to deface Mr. Brackman's car, correct?
Okay, hold on. Let's deal with the objection. Go ahead. Speculation.
Yes, speculation.
Which part? Marching out?
Your Honor, Mr. Perkins cannot accurately testify to Avery Becker's emotions and that she was so upset that she did certain actions.
May I reply?
You may.
The witness has testified to knowing Avery, how upset Avery was about this incident in his statement that he made prior to this trial and today in court.
Anything else?
I stand by my objection, Your Honor.
All right, well, I don't think this witness can testify to the emotional state, but if indeed marching out and the behavior and what happened beforehand gives this witness context, I'll allow the opinion to be given overruled.
Thank you, Your Honor. So Avery did deface Mr. Brackman's car, correct?
Well, I mean, like I was saying, I think the word deface implies she meant to vandalize his car. I mean, did she mean to tell him something that was maybe a little mean? Yeah, but I don't think she meant to do any personal or any lasting damage to the car. I think she was more just a little upset and wanted to let Brackman know how she felt.
Mr. Perkins, I'm not talking about Avery's intentions. I'm simply asking you if she vandalized Mr. Brackman's prized possession, correct?
Well, yeah, I mean, like I was saying, I think that does ignore some of the context around the situation, but yes, she did vandalize his car.
Okay, I'd like to now talk to you about someone named Blair Rollins. You were not friends with Blair Rollins, were you?
Not really. I mean, like, Blair kept to herself mostly. I mean, I know she and Alex were kind of friends, but other than that, I don't really know who she talked to.
But you were also not close friends with Alex Cifuentes, correct?
Well, yeah, I like to keep my distance from toxic people. So yeah, I wasn't very good friends with Alex.
Right, but even with that distance that you speak of, you say that Blair and Alex were good friends, correct?
Well, yeah, I mean, to my knowledge, they were, like, how it was in high school. You see who talks to each other, you see the cliques and stuff. So yeah, from what I can tell, they were really good friends.
But you don't know anything about their relationship, right?
I mean, all I know is what I could observe, but from what I did observe, they were pretty good friends.
But you have never seen them hanging out?
I believe that's outside the scope of my witness statement.
May I rephrase? You have no knowledge of if you have ever seen them hanging out.
Yeah, I mean, like I said, I think they were friends, but no, I guess I haven't ever seen them out together or anything like that.
And you have no knowledge of if either of them ever told you that they were friends, correct?
Yeah, well, like I said, this is kind of out of my witness statement a little bit, but yeah, no, they never did directly come up to me and say, "Hey, Taylor, I'm really good friends with Blair."
Right, so you would have only heard that through some sort of secondhand source, correct?
Well, I just know what I can observe and what I pick up on at school and stuff, but yeah.
Okay, Mr. Perkins, you never liked or respected Mr. Brackman, correct?
I mean, yeah, I think he was always kind of a subpar lawyer. You know what they say, those who can do and those who can't teach. But I mean, he was human. I think he deserves the same basic respect everyone else gets. But when it comes to anything outside of that, yeah, I don't know.
You say those who can do, those who can't coach. You call that respecting him?
Well, I mean, like I was saying, I respect him on a basic, he's a human, I'm a human level. But when it comes to seeing him as a superior or other than basic human respect, yeah, I guess I don't really respect him that much.
All right, thank you. No further questions, Your Honor.
Can you redirect?
Yes, Your Honor. Mr. Perkins, when was the last time you saw Avery Becker's phone?
The last time I saw her phone was sitting on the table at the Fry Shack when we were with Alex, and after that, I don't know what happened to it.
Your Honor, I have no further questions.
Any questions on that one?
No, Your Honor.
Okay, thank you. Further witnesses for the defense?
Yes, we call Avery Becker to the stand. And may I also please have a time check?
Yes, you may. 11:48.
Thank you.
Please. Okay.
Good morning. Can you please introduce yourself for the jury? Oh, Millie, you're on mute.
Sorry. Yes, my name is Avery Becker.
Why are you testifying here today?
I'm testifying because I would like to prove that I did not commit the crime I'm being accused of in this trial. Like fake cries in this.
To start off, I'm going to ask you some personal questions. Were you on the mock trial team at Colorado High School?
Yes, I was. One of my deepest interests was mock trial. I love everything about it. One of my favorite parts is really getting to spend time with Taylor because we didn't get to spend a lot of time together at school.
Who are some of your friends on the team?
Like I said, I was really good friends with Taylor. We spent so much time together, and we didn't have a lot of classes together in school, so mock trial was the perfect time for the two of us to catch up. We liked hanging out with each other and sometimes texting from across the room.
Is there anybody who you didn't get along with on the team?
You know, I would say that I'm fond of most people who were on my mock trial team, but if I'm being honest, there was always something off between Alex Cifuentes and me. It wasn't that we didn't get along, me and Alex. Rather, it just seemed that Alex was jealous of my natural mock trial abilities.
Can you please further explain Alex's jealousy?
Sure. As I said, I do have quite an aptitude for mock trial. It was kind of easy for me to just examine anyone without really preparing, and that really bothered Alex. In addition, I did miss a couple of practices, and I think this particularly annoyed him because Alex worked really, really hard at mock trial, and I simply just didn't need to work that hard.
Now turning to Coach Brackman, did you ever have any differences with him?
Of course, with every relationship, there are ups and downs. Similarly to Alex, it bothered Coach Brackman that mock trial came so easily to me and I missed practice a few times, but he knew that I had an instinct for mock trial. And when I found out that Coach Brackman had been murdered, I was devastated.
Were you involved in an incident with Coach Brackman's car?
Yes, I was.
Okay, please explain this incident to the jury.
So before regionals, Coach Brackman moved me down to B team for a while because he claimed that I didn't prepare enough and that I just didn't deserve to be on A team. But then he moved me back up eventually. At regionals, I won a Best Attorney award and even a Best Closer award. After the tournament, Coach said that I didn't deserve the award and that I was going to make our team look bad at state. I believe he said that I was just relying on my good looks and that I was just lucky.
And what happened next?
I was really angry. I stormed out of mock trial practice, and we had been doing something on the whiteboard, so I had a whiteboard marker in my hand, which I later learned was a permanent marker. I took said marker and drew all over Coach Brackman's car. I thought it was a dry erase marker. I would never intentionally draw on his car with permanent marker, no matter how mad I was. I genuinely thought it would wash right off. And understandably, after that, Coach Brackman did kick me off the team.
Did you ever try to apologize to him?
Yes. The next day, I went to his office, but his secretary said he was busy and didn't want to talk to me. I sent him a text message, and I told him how sorry I was and that I would try and clean the car myself, get a summer job in order to pay to get this car repainted, anything to fix this horrible mistake. But Coach Brackman never responded, so I never got the chance to apologize to him before he died.
He never responded. Let's move to the day that Coach Brackman was killed. Do you remember where you were that day?
Yes, I do. I remember it clearly. The day before, on March 5th, I was with Taylor at the Fry Shack, and then Taylor and I went to the mall. But I'd lost my phone that day, so the next day, on March 6th, I went to Taylor's house, and since neither of us had really anything important to do at school that day, we decided to skip school to try and find my phone since it was missing. So Taylor and I were together the whole day, retracing our steps at the mall and the Fry Shack, just trying to find my phone.
Is there any time during the day that you weren't with Taylor?
No, like I said,
Response?
This isn't on a leading question, as I'm not asking for an answer, no yes or no question. I'm asking for like her recollection and for her to explain the time of day that she was with Taylor.
Anything further?
Your Honor, the question suggested its own answer. If co-counsel or opposing counsel could potentially rephrase.
I'm overruling the objection. I don't see that as a leading question. Go ahead.
I'll repeat the question. Is there any time during that day that you weren't with Taylor?
No, Taylor and I were together the whole day because we couldn't find my phone and we kept using hers to call mine, but it never answered. So no, Taylor and I were together the whole day.
Do you have any idea where your phone was?
Well, I know for a fact that I did have it at the Fry Shack because while we were there, Taylor and I were playing video games on our phones. And a bunch of people from my school were there, including Alex Cifuentes. I think he took my phone.
Why do you think that?
It's my understanding that Alex claims to have received a series of text messages from me stating that I wanted to get back on the team. And apparently I texted him and told him that I wanted to go to Coach Brackman's house to trash it. But I never did that. And I don't even know where Coach Brackman's house is. And I never would have texted Alex that.
Can you please take a look at what has been previously admitted as Exhibit 14?
Yes.
Remind us, what does the time say on the text messages?
It actually doesn't look like there's a time attached to these text messages.
Did you send these text messages?
Absolutely not. Like I stated earlier, my phone was missing, so I could have never texted Alex without it.
Moving on, you earlier mentioned Blair Rollins. Who is this?
So Blair's another student at Colorado High School, and Blair and Alex, from what I know, seem to be close friends, but I never talked to Blair much. But I do know that Blair did not like Coach Brackman.
Why is this the case?
Coach Brackman lost Blair's father's case, which ultimately sent Mr. Rollins to jail.
Interesting. Avery, can you describe Blair's physical appearance?
Well, actually, Blair and I have a similar height and a similar build, so people would actually always confuse us.
Moving on, can you please take a look at what has been previously admitted as Exhibit 12?
Yes, I can.
Can you remind the jury what these are?
So, it looks like a video of an intruder walking up to what I assume is Coach Brackman's door, either the front or the back, but I wouldn't know because I've never been to his house.
Can you recognize any of the intruder's appearances and relate them to yourself?
Well, from this short clip, I actually do notice that the intruder has a similar height to mine, but that just as well means that this person's height is very similar to Blair's, and you can't tell at all who this person is because they're wearing long sleeves and a mask other than the height and build.
Finally, did you kill Coach Brackman?
Absolutely not. The only thing I did was damage Coach Brackman's Porsche. I feel so horrible. I shouldn't have done that. I did not kill Coach Brackman, and I just can't even believe that I would be accused of this.
Thank you. No further questions.
Cross-examination.
Yes, Your Honor. Hello, Ms. Becker. I'm Eleanor Hunt, and I'm an attorney with the prosecution. You went into practice that Tuesday night after regionals, expecting a pat on the back from Mr. Brackman for your role in the team's success, right?
Well, yes, I had won a couple of awards, so I had expected some acknowledgement.
That's not what happened, though, is it?
No, Coach Brackman said that I was relying on my good looks and that I was just lucky to have received those awards when I really just did well in the competition.
He said you were undeserving of the Best Attorney Award, right?
Yeah, he said that I was going to make the team look bad at state or something like that.
You got upset.
I mean, I deserved the awards. I was honestly really good at mock trials, so it did frustrate me that Coach Brackman didn't recognize that I deserved the awards.
You were outraged that he didn't recognize that you deserved the awards.
Yes, like I said, I was frustrated.
You stormed out of the room.
I did.
With a marker in your hand.
Yes, and I genuinely thought it was a dry erase marker.
Right. And you saw his Porsche in the parking lot.
Yes, I did.
And you scribbled Worst Attorney Award across the hood.
Yes, and I thought it would wash right off. I should have never done that, and I feel so incredibly horrible.
And you claimed today that you thought it was a dry erase marker.
I did, of course. I would never draw on his pores with a permanent marker.
But it was a permanent marker, wasn't it?
It did happen to be a permanent marker. I just don't understand how this happened.
You were out of control at that moment.
Yes, I was. I was really frustrated with the fact that he didn't recognize my awards, and I wanted to do something that would make myself feel better. And looking back, it was one of the worst mistakes that I've ever made.
And when Mr. Brackman came out and saw what you had done to his car, he kicked you off the team.
Understandably, what I had done was absolutely horrible.
You did a horrible thing.
I did.
You texted Alex Cifuentes.
No, Alex and I aren't friends. I would never text Alex for help.
Objection to relevance to the previous question.
Response?
May I respond?
Yes.
Your Honor, this is a concerning Exhibit 14, which counsel has previously mentioned in her direct exam. This witness has testified to it. I'm simply asking a follow-up question to this evidence.
Response?
I stand by my objection.
Well, I don't have much to go on with that objection other than it's irrelevant. Certainly seems like Exhibit 14 is in evidence and it does explore the relationship between the people the question is being asked on overruling the objection.
Thank you, Your Honor. Your Honor, permission for co-counsel to screen share Exhibit 14 at this time?
Go ahead.
Ms. Becker, you claim you never texted Alex Cifuentes, right?
No, I did not. My phone was missing, so I could have never texted him. Second, I would never text him.
According to these messages, though, that have been accepted by the court with your name, you were planning to break into Mr. Brackman's house.
We have no proof that these text messages were coming from me. My phone was missing, so like I said, I could have never sent these text messages.
Ms. Becker, I know you say that you did not send these text messages, but these text messages that have been admitted by the court indicate that you told Alex Cifuentes you were planning to trash Mr. Brackman's house, do they not?
If I'm correct, I think these text messages were not admitted for their validity, rather just admitted into evidence, and we have no proof that they were, in fact, real.
But they have been admitted by the court, which must give them some weight.
Yes, they have.
These text messages show that you had a plan.
Like I said, I didn't send these text messages, so whoever did was trying to make it look like I did want to go to Coach Brackman's house and trash it, but I obviously didn't send these.
Ms. Becker, I'd like to go back to the night you vandalized Mr. Brackman's car.
Okay.
Ousted from the A team, you went home and told your mom what had happened, right?
I did. I was so frustrated. My mom knew that I deserved the awards too.
Well, not everything. You conveniently forgot to tell her about your vandalism.
I felt so horrible, and I honestly didn't even want to think about it again. I just wanted to apologize and get the whole situation fixed, and of course, I didn't tell my mom. I couldn't let her down like that.
But what you did tell your mom is that you would get back at Mr. Brackman if it was the last thing you did.
I wanted to be on the team for state, and I wanted to be a part of the team.
No further questions, Ms. Becker.
Correct.
Yes, Your Honor. Do you regret vandalizing Coach Brackman's car?
So incredibly horribly. And I tried to apologize. I tried to text him. I just wanted to fix the situation. I can't even believe that I did this.
And finally, did you send the text messages in Exhibit 14?
Like I said, my phone was missing the whole day, and I'm not friends with Alex Cifuentes. I would have never texted him for help. I couldn't have even texted him for help since my phone was missing. No, I did not send the text messages in this exhibit.
Finally, did you like Coach Brackman?
In fairness, Coach Brackman did have a massive ego, but he got our team to a great place. We were at the top, we were competitive, and I may have sometimes gotten occasional arguments with him, but I genuinely loved Mackenzie Brackman as a person, maybe in a less obvious kind of way. but I just can't even believe that it's come to this.
Thank you. No further questions.
Further questions from the people?
No, Your Honor.
All right, thank you. The prosecution ready for closing argument?
Yes, Your Honor.
Okay, you can proceed when you're ready.
I would just like to clarify that any remaining time will be reserved for rebuttal.
Fine with me.
Thank you. Ousted, outraged, and out of control. Ladies and gentlemen of the jury, Miss Becker was used to getting away with everything until everything got away from her. On March 6, 2020, Avery's emotions got the best of her for the third and final time. The first time, she was ousted from the A-team. The second, she was outraged by Mr. Brackman's constructive criticism and irrationally turned to vandalism. And the third time, everything got out of control. Avery was kicked off the team and felt like she'd been stabbed in the back. Her response? To do the same to Mr. Brackman. We must prove beyond a reasonable doubt, not just any doubt, certainly not a doubt which is in any way vague, speculative, or imaginary, that Avery committed second-degree burglary and felony murder. We don't need to prove Avery intended to kill Mr. Brackman. Rather, her planned burglary got out of control, resulting in the killing of her coach. Today, we have met this burden. As I walk us through the evidence, you will see the answer lies in 4 simple questions. First, did Avery enter Mr. Brackman's home? Yes. Detective Markowitz, an expert in cell tower analysis, testified that Avery's phone placed her near Mr. Brackman's house during the date and time of the crime, and provided ring footage, which showed an intruder of the same size and build as Avery entering the home. Now, the defense attempts to discredit Markowitz's findings with Van Owen's speculative review of the information, not even a true investigation, and then goes on to provide a less credible alibi, claiming Avery and Taylor spent the whole day looking for a lost phone. If that doesn't raise enough doubt, let's take a look at the source of this unlikely story. Taylor, the same Taylor who quit the mock trial team for Avery, the same Taylor who is Avery's best friend. Second, was Avery invited to Mr. Brackman's home? No. Ladies and gentlemen, no one greets a welcomed guest with a kitchen knife drawn in self-defense. Third, did Avery plan to commit a crime? Yes. Not only did she tell her mom she was going to get back at Mr. Brackman if it was the last thing she did, but she texted Alex about Mr. Brackman's home saying, I'm going to wait until he's at work and then break in and trash it. Ask yourselves, does that sound like a plan? And lastly, was Mr. Brackman killed in the course of these events? Yes. Expert witness Kyle Kuzak walked us through every single link in the evidentiary chain, showing how Avery broke into Mr. Brackman's home. The two struggled through the kitchen, knocking over plate, and in the midst of the chaos, Avery grabbed his knife and stabbed him back, leaving him to bleed to death. Now, the defense falls short again in their efforts to disprove this with their check on the power of the police, Van Owen, claiming that all this evidence is merely speculation. And with what evidence to show that? None. Just like every other quote unquote flaw she finds in the police investigation. We know Avery had a special talent to pull it all off. She had won awards in mock trial as a witness, testifying from the same stand in which she spoke to us today. But this is no longer mock trial. Actions have consequences. Find Ms. Becker guilty of felony murder and second-degree burglary. Thank you.
Thank you. Ben's closing.
Yes, Your Honor. The prosecution must prove beyond a reasonable doubt that Avery Becker murdered Mackenzie Brackman. The prosecution failed to meet this burden due to several key facts. First, the investigation was rushed and sloppy, and no other suspects were considered. Second, Avery was not at the crime scene and has an alibi, which Taylor Perkins can support. And third, and most importantly, the evidence in this case points to two alternate suspects, Alex Cifuentes and Blair Rollins. The prosecution tried to convince you that Avery murdered Coach Brackman because she was demoted to B team. But Alex and Blair are the individuals who have motives. Alex's desire to become a mock trial star, and Blair's desire to get revenge against Coach Brackman for losing the case that sent Blair's father to jail. First, the prosecution's key expert witness, Detective Markowitz, clearly rushed the investigation. As Ms. Van Owen told you, Detective Markowitz jumped to conclusions with the knife and the cell phone tower data and never considered other suspects. In addition, Detective Markowitz ignored the fact that there is no physical evidence that connects Avery Becker to the crime scene. No fingerprints, no DNA, nothing. You can't even see who the assailant is in the ring videos. Second, Avery Becker was nowhere near the crime scene on the day of the murder. Taylor Perkins, Avery's best friend, testified that Avery lost her phone the day before, and that the day of the murder, he and Avery were looking for her lost phone the entire day. In addition, Mr. Perkins acknowledged that he and Avery were nowhere near Coach Brackman's house when looking for this lost phone. Avery can support Taylor Perkins' testimony. As she explained, she did lose her phone, and she explained that the text messages that Alex claims to have received from her are fake because she can't send text messages without her phone. Third, Alex Cifuentes had a dream and a plan. As Avery testified, Alex is jealous of Avery and wanted to get her out of the way. Alex went to every practice and prepared for every trial. However, none of this dedication or work allowed Alex to outshine Avery in competition. This is because Avery is an accomplished individual who has incredible mock trial abilities. Imagine how frustrated Alex must have felt working as hard as possible, but never being able to outshine Avery. Meanwhile, Blair Rollins has a reason to despise Coach Brackman. Coach Brackman lost the case that sent Blair Rollins' father to jail. This makes it easy to see why Blair wanted revenge against Coach Brackman. Alex had a dream and a plan, and used Blair's desire for revenge in order to accomplish it. As Alex wanted Avery to go to jail, and Blair wanted revenge against Coach Brackman. This was the perfect crime, as it would ruin both the lives of Mackenzie Brackman and Avery Becker. Members of the jury, the prosecution did not meet its burden. Not only did the prosecution shortchange its investigation, but Avery was not even at the crime scene and has an alibi, which Taylor Perkins can support. And most importantly, the evidence points to two alternate suspects in this case, Alex Cifuentes and Blair Rollins. I ask you to find the defendant not guilty.
All right, thank you. Any rebuttal?
Yes, Your Honor, briefly. May I begin?
Sure.
The defense called this jealousy and rivalry gone too far. They're right. Things did go too far. In fact, they got out of control. But it wasn't jealousy and rivalry. It was Avery's outrage and her planned burglary. Thank you.
All right, thank you, everyone. Hard to give everyone a hand, but we would give you a rousing round of applause if we could. I will tell you a few of my comments while our scorekeepers catch up and do their duties concerning their scores. I think everybody did a wonderful job on this case. If I had to make one overall observation, it's that you did a great job of sifting through the evidence on both sides and focusing on kind of your themes and getting rid of the sort of extraneous facts and evidence, of which always in these mock trial competitions there are tons. I used to handle a lot of medical malpractice cases when I was an attorney before I became a judge, and you have tons and tons of depositions often in those cases, which are like your witness statements. You have tons and tons of records, medical records, both, you know, leading up to maybe a malpractice event and then the record afterwards. You've got lots of complex expert opinions because they're all about doctors or medical providers, and that profession, those folks tend to not have any shortage of opinions. And there's tons of research. And then maybe most importantly, the thing to not overlook is the human story. And I think what you do is you end up being like a snake eating an elephant. You know, you have all this information, and it's a very hard story to tell because you're distracted by all these little details. And I think that's what I would say make both of your teams good teams, in the sense that you were able to, you know, kind of less is more. And that's the skill of real lawyers, storytellers, maybe psychologists, you know, hundreds of professions where you have to take massive amounts of information and get down to what's important. So you learn a skill just by doing it, so to speak, so that you can be convincing and persuasive. It's unfortunate, of course, that we have to do this tournament by Zoom. There are some pluses and minuses with that. Number one is the screens force you to focus on the witness. I happen to be sitting in my courtroom this morning, and I have the lawyers over here, and I have the witness almost behind me back here on the witness stand. And it's a one big tennis match back and forth between questions and answers. Sometimes it's hard to follow. Sometimes, you know, there's always a question or two where you want to be looking at the witness to see how they answer it. What is their expression like? Did they pause? Did they delay? Did they swallow hard? You don't get to miss that on the screen. So in some ways, one of the jobs I have to do is judge credibility. And I get to judge credibility, frankly, almost better on Zoom. I don't miss the nuances because I can look at both of you at the same time, the questioner and the answerer. Also, you all get to kind of use your notes more than you would be in person. because you can have them up there by your screen or on your screen, you know, if you use a split screen. So that's a good advantage. And I'm sorry you don't get to come in here and, you know, feel the pain of being in front of people, kind of the public speaking part of it. You get it a little bit, but that's the part you're missing. And hopefully you develop those skills soon when the world kind of normalizes, and also through other opportunities. But that's an important part of lawyering is mastering those nerves as well as you can, and in many things in life, obviously. I think the objections were pretty well used. I kind of look at objections a little bit like seasoning. You know, if you're enhancing the dish with the right kind of seasoning, great. But you can over season a dish. You can distract from the story. It's hard to think on your feet. Should I say that or shouldn't I? And sometimes you get trapped, and it's like, God, I should have objected to the last question, so I better object to this one, and that's not as good as objection as the last one might have been. But that's all part of the skill you're hopefully developing, is thinking on your feet, or as we're all doing today, and as I do in my job, thinking on your rear end usually, you know, so it's not quite the same thing. There were a number of good use, I think, by a number of folks about using, you know, questions that you don't care what the answer is. You're just trying to say, well, you didn't do this, did you? Or you did this, or you went there next, and you don't care what the witness says. I thought every time that was used, that was another thing. You can't overdo it. You can't make an entire examination of that. You know, any jury wants to hear what the witness, especially the defendant, has to say. It's very rare to hear a defendant testify in most criminal cases. The defense is forced with calling the defendant here, and that's just part of the game, so to speak, the kind of mechanism of mock trial. But you probably would never call the defendant in a case like this. But this is all about the people and their personalities, and you did a good job of bringing those things out. You have a lot to work with in this case on that. You know, the prosecution's case is all circumstantial concerning the defendant. I mean, we have more than adequate evidence of the death and how, at least the method, by virtue of knife. The rest of the prosecution case is largely circumstantial, even though we have a picture of the perpetrator, but we don't know who it is. And the defense has an equal challenge of having to kind of convince a jury of self-defense, which is hard when you can't admit even being involved in the affray that, you know, raised the need for the self-defense. So interesting case, a lot more interesting than it appears maybe the first time you read it. There's a lot to work with there. I think you all did a wonderful job. I'm not sure strategy-wise, one thing, and I know it's a little late to rethink strategy, but it just struck me, and I don't know how important somebody's car is after they're dead. That's a lot more important fact in their life than condition of their car. But who knows? Maybe that works with people, maybe it doesn't. So let me turn to our scorekeepers. I know we have, maybe we can start with John Logan. Mr. Logan, you're very experienced attorney. I see it in front of me, and we've known each other for a long time. And thank you for your volunteering in this year after year. Comments you might have?
I do, Your Honor. Thank you. And to all the students who participated today, you guys are awesome. As the judge mentioned, I've done this mock trial judging for probably 25 years. And I will tell you that both of you, both teams, are among the very top teams that I have seen in all that 25 years. Your preparedness, your competency, your knowledge of objections, I think was outstanding for both teams. So you're all to be complimented. I think you were great. I loved your themes. I loved your knowledge of the facts. And I loved your passion. If I had one word of advice, and I'm not picking on any one person, it's just sort of a universal truth in this sort of thing, is relax. Just relax, and relax and respond. I think maybe if I could expand that. In other words, when a witness gives you something that's off track, that's not the answer you have, 1 through 20, go with it. Take a little side trip down the road, see where it takes you, and just play with it. It's funny how much you can get when you get off script. So that's I think an important thing to do. But overall, just an amazing job. Seriously, you guys are both among the top teams I've seen in over 20 years of judging this. So be very, very proud of yourselves.
Thank you. And we'll just go down the line. Ariel Barron, she was my law clerk for several years. Observations you have?
Thank you, Your Honor. Yes, I thought across the board, I think your composure was really great, especially with not reacting to or drawing extra attention to mistakes, which are expected, I guess, to happen through Zoom, because we had a few technical issues, and I thought you guys just handled it well and supported each other, not taking it to be an adversarial moment, which is good. Juries like seeing that, or in this competition, juries like seeing that. And then also specifically, I thought Miss Kim and then Miss Davies, like when you were, I think it was on cross-examination, specifically, I think Miss Kim, you said, I didn't ask, and then specifically I tried to redirect the witness. That was great. And then similarly, Miss Davies, you would just holding the witness to an answer saying, so is that a yes? I mean, I think I wrote down a few instances where I think almost everyone did that, but it does get hard. And that's where it's so fun to watch this play out, where you guys are so prepared, but then you get the extra moments where it's kind of unexpected and spontaneous to really kind of be as an attorney would be in the courtroom, because you wouldn't have gotten to run this as many times as you have. And it's just, you guys do a great job with that. And then also with the witnesses, I thought Mr. McKissick and then Miss Ham, you guys were unwavering. I think Mr. McKissick at one point, I forgot that you weren't this actual person, just because you were so conversational and everything. It was just so believable. Miss Ham as well. I mean, you think it was just, I could believe if you had like a police uniform on that you could have been a detective. So I guess another small thing is just whenever you make an objection, even if the judge doesn't rule in your favor, you could just still thank him. It's probably hard after in Zoom to not over talk people, but even if he doesn't rule in your favor, it's still just can be like a nice thing to go along and recognize that maybe also you're not upset. No one seemed upset, but then it just helps that I guess keep going. But yeah, I agree with what Mr. Logan said. This is my second year watching this, and you two, both teams were phenomenal, and it was just a joy. It was so fun. You really should be really proud of yourselves. It was some of the best I've seen. So I think I've seen like a dozen at this point in 2 years. So it was just really, really, really great. Thank you.
Well, thank you. And Ms. Wood, you've volunteered a few years for this. Why don't you tell us what you're doing these days? You were working for the court. You're not an LRA, are you, or are you?
I am now a deputy district attorney with
Oh,
the
great.
judicial district. I have to say, I thought you all did an excellent job. This was a really, both teams are really well matched against each other. So this was a really close call at the end of the sheet. So you should all feel really proud of what you've done. I just want to say this was just super smooth. I know it's really awkward on Zoom, but just when I say smooth, I know sometimes in mock trials, people get kind of stuck to their scripts, stuck to what they think. And throughout this entire thing, all of you did an excellent job of reacting to what was actually being said and the arguments that were being made. I thought you all had a great grasp on the rules of evidence, and you just did such a great job really focusing on what was going on just this morning. And you all were clearly very well prepared.
Well, thank you. And I didn't want to say this because the scorekeepers might have still been scoring at the time, but yeah, this is high level competition, two good teams, tough call. I'm sure it was. I'm glad I didn't have to score this one. I'm sure our scorekeepers, I don't want to invade their province here, but I'm sure they had you within a point or two on both cases. You know, the determination would have to be on very small points because very good job, and best of luck to all of you in the next round. And yeah, I'd go with Mr. Logan. Everybody relax, at least in your break here between now and the next round, okay? Hopefully you're having fun. Good luck.
And Judge, before you go, I will just make sure, I believe all the scorekeepers have their sheets in. Is that correct, scorekeepers?
Yes.
Got 3 thumbs up. All right,
Looks
Judge.
like it, yeah.
I would just, from the bar, thank all our scorekeepers, our volunteers, as well as you, Judge. Thank you very much. They're yours to do with what you will now, sir.
All right. Well, court is in recess. Let's say that. All right. Bye now.
Thank you so much.
Thank you, Your Honor.
Oh, Judge.